Yes, brother.
Minors,
Yes, sir.
this petition has been filed. Where I have
Make use of the mic. Be louder. Nowadays, without loud voice, nothing will happen.
Writ appeal has been filed against the order of the Honorable Single.
When do you want?
Minors,
When do you want?
any date according to convenience of the Honorable Court.
25th of this month. Next week we will have that. Any urgency?
I am not getting my area salary.
Your salary.
Item 43.
We'll go by phase one. Always. Wait. Yes, pages. Only 4 persons. Yes, which is your number?
Item 43, my lord. 43. In this, I have received the counter, my lord. Not filed the rejoinder. 2 weeks time for the filing rejoinder, so that's open hearing.
2 weeks for filing rejoinder finally. At the request of. Yes.
The writ appeal, Mr. Das. You must understand.
Yes, ma'am.
Yes, ma'am.
They have already filed counter.
My lord, item 38. It's a personal appearance.
Then we will say only, brother, it should not be construed that you have permitted to file a return. Call this matter of 2 weeks at the request of.
No, my lord.
It's not my
Personal of secretary and the.
No. That matter.
Sorry.
43.
Mr. Das,
Yes. Yes.
Regional line.
May I please?
Yes.
My lord, item number 38. It is regarding the appointment of the professors and associate professors in all medical colleges. There is a direction and request for the secretary and the DM to be present. So we are filing to the counter. They have come. Can it be taken about 12 o'clock?
12 o'clock. If they are present, you can take it now.
No, but they
will come at 2.
No, they will come. Then on the
Wait, I'm sorry. I got 2.
12 they will be coming.
Yes.
Midday. All right. No problem. Let them
You can mention.
that you can mention.
Yes.
Item number 37. So you are satisfied with the counter? It's a PIL. The nature is a PIL.
Government is going to file counter.
To file the counter. I have got the counter today. We are not
The question is different.
Yes.
Both of you have gone through the counter and satisfied that adequate steps are being taken to fill up.
They have established a new medical college and they are going to apply.
No, they are the regions
Not the
not
answer.
able to. We will have to stand steps.
Let us.
I have said.
Take out LIC of India versus swine suit. Karnataka Dharwad bench judgment. Affirmed by the apex. Take out of that. LIC of India versus swine suit. 2024 perhaps. Yes.
Item number 37, my lord. In this case, I am appearing for the appellant wife. My daughter and friend is appearing for both are bank employees, my lord. On the last occasion, Lordship have observed that talk of compromise is going on. We prefer only short date, my lord, because they are bank employees and also they are having a male child, my lord.
No, 1 month time.
Yes.
Why 1 month?
But they are not getting leave actually.
Leave they are not getting. We will direct a bank to grant leave so that they will sit under the shadow of a tree and work out their remedy. 2 weeks.
When do you, because if you want that kind of a direction, but please mention.
Yes.
That when both of you will apply, they're in the same branch or same place or
Different
Different.
branch. Both are managers.
We cannot be.
cannot be
It's a matter of policy.
policy. But I mean, employer is saying which bank. So you mention when it reaches any one of you, the order has to be passed.
And file cannot be withdrawn from the pool.
One chance may be given thereafter.
We'll give.
One chance will also be given me.
So you are not following, sir. Chance already given. Still you want to say one more chance.
We'll
But you give us a chance to go through the list and reach there.
We'll see the file.
We are seeking a chance from you.
Please wait, please. We'll do something. Yeah.
Page 12, 13 to 41, page 13, 14.
Over. Nobody is there. No. Yeah.
Can you see anyone is there?
Item 1,
Lord, in this item 1, what I would like to submit before your lordship, I am for the State Bank of India. What has happened? The liquidator has rejected our claim for additional proofs. And we have filed an appeal, though nomenclature as an appeal, my lord, under 460, clause 6 of the Companies Act, read with Rule 164. What I want to submit.
Sorry to interrupt you.
Sorry, my lord.
Appeal is our jurisdiction.
Yes,
This court is.
I am extremely grateful to your lordship. This is to come up before single bench. Now, 24/6
Open has to become.
No, though, my lord, it is nomenclature as appeal. Though it is an order of the liquidator, it is to be challenged before the single judge. But when I went through the records, I found that on 24/6/25, the registry has wrongly sent it to your lordship. So by virtue of this, actually section 48,
I could not follow you.
my lord,
No.
This is not a COA.
this is,
Wrong nomenclature you are saying.
no, it is to be nomenclature as COA, my lord, but it is to come up before the single judge.
Order is by whom?
My lord, order is of the liquidator. What has
Then
happened?
it has to go before the single.
Yes,
And this copet also. The
copet is pending. Copet is pending before the single judge. So, my lord, it has to come before the single judge, my lord.
Correct, you are right. Ramaya's company law says as you have said now. A Ramaya.
Well, having company with great difficulty I could get because it is an act which is already no more in existence.
Yes. Anyway, right of appeal is to be decided. As on the date, the cause of action arose.
That decision I am having of the 57 Supreme Court Constitution bench.
Very.
I need not elucidate your lordship.
Yeah,
Yes, below.
understood.
Only for my satisfaction I have got it.
Registry to post the appeal in question before the learned single judge of this court, before the roster single judge of this court, since what he challenged is not the order of the learned single judge, but OL's order dated 29/7/2000, 29 dated
Annexure 14, my lord, I am giving.
tell the date.
Ma'am, one second.
Right, OL's order.
11, page 48. 11th August 2010.
All right.
Deeply obliged.
All right.
And if anything does not survive, then please move this. I mean, let it be disposed of. That is also a request.
My lord, because your lordship was kind enough to allow me a soft copy, even the bank is not having records. It's a matter of 2010-11. Right.
Yes. Okay, that's how it. Yes.
This is
Fresh matter.
Appeal 1124.
Yes, my lords.
Say something on merits.
My lords, the writ appeal has been preferred against the order.
No delay.
No delay. But application is filed.
Disposed application is.
Since appeal is filed within the period of limitation, application seeking condonation of delay fails into insignificance and accordingly disposed of. What is the matter on merits, brother?
My lords, writ appeal has been preferred against the orders by the Honorable Single Judge on dated 2024.
Correct.
My lords, writ application was filed by the appellant being the petitioner to avail a writ in the nature of quo warranto against the private opposite parties and subsequently upon the satisfaction of the Honorable Court, destitute the private opposite parties from their offices. My lords, it is relevant to mention that the respondent number 1 had issued an advertisement for recruitment of assistant professor teacher education stage 1. Well, it's a bare perusal upon clause number 4 of the advertisement substantiates that in order to be eligible for the post of assistant professor teacher education stage 1, a candidate must possess single master's.
You are a candidate also.
No, my lords.
Claim.
No, my lords.
PIL.
Writ in the nature of co-warrantor.
Correct.
Yes.
But this Orissa High Court, 2 writs have gone to Supreme Court, have been confirmed. The scope of judicial review in a kind of a PIL prayer, which are those decisions?
My lords, I rely over a different
decision. Those 2 decisions from Odisha going to Supreme Court.
No, my lords, I haven't.
Kindly go through that.
My lords, if the Honorable Court permits, I have.
Sir, kindly you have to appreciate. You have already lost the case. Don't raise law.
No, my lords.
Both are from Odisha.
My lords, this isn't
Suppose what would be the scope of review? Now it will be much stricter scrutiny because already you have lost it. Heat appeal or say would be a lesser scrutiny as far as the law is concerned. You can file, but what is the scope? Which are those cases?
My lords, I have a judgment. If the Honorable Court permits, I would like to rely.
You don't require any permission. But I request you to answer the court's query.
The 2 judgments which Honorable Court is asking, I haven't gone through. But
then how could you see those are relevant because
let us see that judgment which he wants to file.
Those are on doctors.
My lords, the issue I may have.
Which is the case on doctors? The same.
This isn't a PIL, my lords. That's where I stand.
Not listen. That's the problem. Review. I have never said PIL. The nature is PIL.
You are not a competitor.
Yes.
What is the character of PIL? Because you are not one of the contestants in the fray. Correct. Yes. In that nature, we are saying because of CD Govindarao.
CD Govindarao has been followed in that decision. The latest being M.S.Sahoo was chairman of some earlier one is Dr. Misra.
Just look into it, come back.
But let him show that but he is not prepared to show.
No,
you can show those decisions what you are saying.
Yes, minutes.
Exactly your prayer, assistant professor.
Miller's paragraph number, page number 504.
No, straight away don't go to 504. Have they considered, is this regarding the service of an assistant professor or like that?
Yes, Millers, the issue is similar.
So this is regarding this service. Look at the paragraph 1, leave granted.
Yes, Millers.
So chairman of OERC is different and selection of assistant professors in medical colleges or in Odisha Health Service is different.
Millers, but the principle.
So there is direct decision on this point. You have to understand that the reason for rejection of your prayer.
Millers, the reason for rejection of the prayer is Honorable Court appreciated the judgment, which Rajesh Awasthi's judgment, which is in front of the Honorable Court. But the single bench suggested, without taking into consideration the NCT regulations, has said that the advertisement as well as the OES rule prescribe a single or dual master's degree, and the private opposite parties are possessing single master's degree. But Millers, if the Honorable Court peruses the advertisement as well as OES rules, which has been framed under Article 309.
Challenge your Dr. Duryodhan Sahu versus Jitendra Kumar Misra.
Millers, then I'll peruse those 2 judgments and
just look into
that, because this doesn't take care. This Avasthi.
Yes, Rajesh Awasthi
has not referred to those decisions.
Rajesh Awasthi is in 2013, Millers.
So that's why decisions are by 2 judges only. You mean to say they don't have requisite educational qualification?
Yes, my lords.
Therefore, whether you are one of the contestants in the recruitment fray or not, you are entitled to seek quo warranto.
Yes,
That's it.
irrespective of we have participated or not
Or not, you are
participated,
entitled.
whenever a post has been holded without the proper qualification, in that case, writ of quo warranto is maintainable according to the judgment which I am relying, my lords.
That's chairman of OARC doesn't require any qualification.
Chairman.
Chairman of the Electricity Commission doesn't require any basic qualification like MBBS, ND.
Well, this is assistant professor teacher education stage 1.
And this is by again by Justice Deepak Mishra.
Yes.
Central Electricity Supply Utility versus Dubey Samudi. 14.1 SCC.
No, what he says, this is not that case. Yes, says these are teachers' posts. What teaching posts?
Well, I would have been misconstrued. If the Honorable Court gives me 1 minute, then I can.
No, sir. Don't you can take the entire day, but we have a time constraint also. The other one, M.S.Sahoo versus Jitendra Kumar Misra, 1998, 7 SCC 273. And some of the learned seniors present in court have seen these judgments and these litigations also.
Is considered. Mandalal is considered. Teacher select the qualification. Contention.
Malus learned single judge suggested that though a writ in the nature of quo warranto in this kind of circumstances is maintainable, but the private opposite parties do have requisite qualification, and that was stated by not taking the NCT regulation into the picture. If the honorable
Which prescribes
dual master's
graduation.
Yes,
Double degree.
Dual master's degree. Yes.
Dual master's degree.
Yes, my lord.
Only one degree.
Yes. My lords, if the Honorable Court permits, I would like to peruse the relevant paragraph of the judgment.
Which is that paragraph, brother?
My lords, page number 43 of my writ application.
43.
Yes.
Scroll to 43.
Having heard learned counsel appearing for the parties and after going through the material available on records,
possess a master's degree or dual master's degree. Master's degree is also there.
No, Mallards,
It's not there.
no, that isn't the case. Mallards, may peruse page number
Sir, can you
58.
can you just assist her?
Yes, Mallards.
That regarding requirement of both the degrees and
Yes.
NTC qualification
Yes.
is mandatory.
Yes, Mallards.
So where you have raised that issue and that has been answered.
Mallards may peruse page number 31 of my writ application.
No. By which rule or any notification you rely on that NTC, the requirement that should show that straight away.
Yes, Mallards. Mallards may peruse page number 58 of my writ application, Mallards.
It is a gazette, doesn't it starts at page 55
Yes.
without what is the title of that? At least you should give always the first page.
Yes, Mallards. The preamble part, Mallards. Appendix 4, norms and standards.
Provision, substantive provision on which you rely.
Mallards, relevant page 55, annexure number 3.
So 55 is,
It is beginning from 55, writ application.
look at 55, it starts with 6.3. Doesn't
No, Mallards, below that, appendix 4, in middle of the page.
Sir, if it is a statute, what is the title of that? That I'm asking you. This is what? 55 is what?
Rules, regulations,
Regulations.
What is the name of that?
Appendix 4, there are different appendixes.
No, the name of the regulations.
NCT regulation,
NCT
appendix 4.
regulation.
1000 put that has been quoted in have a glance to page 38.
No, he's showing that page, so don't get, but he's not sure what he's showing, so that's the problem. Appendix,
Appendix 4.
where you are getting that? In the right hand margin.
Yes. Below that, norms and standards for bachelors of education program leading to bachelors of education degree. Point number 1, preamble. The bachelors of education program, generally known as B.Ed, is a professional course that is for upper primary.
You don't have to read the thing. We did never ask you to read also. Which part of that appendix, if you are relying on, says that this is the required qualification?
Yes, Mellors. That part is at page number 58.
58 of
Writ application. Yes.
58. Academic faculty.
Mellors, below that,
Qualification.
qualifications 5.2.
Faculty shall possess the following qualifications.
Mellors, clause number C.
C.
Yes.
Curriculum and, pedagogic courses. Postgraduate in sciences, mathematics, social sciences, languages with minimum 55% of marks.
And
Master of Education degree with minimum 55% of mark.
yes, one.
Both are cumulative.
Yes, one general degree, another one is
Another is
professional
master's
degree.
degree in education.
Yes, one is professional, another one is general master's degree.
So learned judge read it as or.
Yes, or because Mellors, there is a reason to that. Mellors may peruse page number 31 of my brief.
31 of your appeal book.
Writ application.
So this is a pedagogic course.
Yes.
What is that course?
Pedagogic courses are courses which are related to education. It hasn't been defined in the regulations or in the NCT Act, but general dictionary definition suggests pedagogic means related to education. Mellors, page number 31 of my writ application is about advertisement. In that educational qualification, if the Honorable Court permits, I would like to peruse only 3 lines.
31.
Yes, of my writ application.
31 is
I don't.
it only reflects the names.
Yes, page from
Santa Kumar, etc.
writ application, Mellors.
Yeah.
Mellors may be perusing the additional affidavit which I have filed.
Correct.
Yes, writ application.
Not writ application.
Yes,
In writ application, your page number
is 31.
51.
From 29, the advertisement begins. I rely on page number 31, Mellors.
Okay. What does it say?
Educational qualification, a must A. Possess a master's degree or dual master's degree for the post of assistant professor teacher education if the guidelines of National Council for Teacher Education so demands, with at least 55% marks or its equivalent grade in concerned relevant allied subject from an Indian university or an equivalent degree from a foreign university. So, Malaj, the advertisement suggests that single or dual master's degree, whatever NCT suggests. Now, let's
NCT has suggested this the degree plus
yes, master's degree. One is MA in masters in science, masters in arts, or any relevant.
What you want to say is learned single just stopped there.
Yes, stopped at the advertisement
by the NCT
yes.
at all.
Stopped in the advertisement as well as the rules framed under 309, but didn't touch the regulation, NCT regulation.
Yes, yes. You argued very well. Great. Even when we asked so many questions to you, you argued very well.
Grateful.
Let us see. But come out with the other two decisions which my esteemed brother has said. Just look into them also.
Grateful.
Issue emergent notice. Who are the parties there? Take out this judgment. Duryodhana Sahoo versus famous judgment in 1998 7 SCC 273. Look into that also. That is not referred in this judgment. Although C.D. Govindrao is referred. Nature of war. It was not contested. If he is not a contestant, yes, then this judgment does not do that problem.
Just
yeah, we have read it, we have understood also, but there is a law does not see. Cardozo says law is like a river, it flows, sometimes it changes its course, is it not that way? Therefore, march of law, the April has to take into account, otherwise May summer will come. That's how he says. Issue emergent notice, returnable within 2 weeks. In addition to taking usual steps, it is permitted to serve copies of the petition along with all the appeal memo, along with all the documents, on the learned advocates who had represented, who were before the learned single judge.
Private respondents' notice wasn't issued.
Whoever there.
Notice wasn't issued, so there wasn't any counsel.
The admission statement will be.
Yes.
Issue emergent notice, returnable within 2 days. You argued well.
Grateful, Millers.
Item 3.
This is an intercourt appeal. The appellant refers the order dated 23/8/2024 under annexion number 1 to the Rectification. The non-single judge rejected the claim of the petitioner for issue of a direction to opposite parties to consider the case of the petitioner with the similar situated candidates who has availed the same benefits.
Availed?
Same benefit.
Same benefits.
Availed. Okay.
Actual matrix of the case is that 2011 advertisement was issued for engagement of Shiksha Sahib. Thereafter, 2011
Paragraph 10 pending. Paragraph 10 of the
Impute order.
Running phase 29, internal phase 9. So what was the material you produced to get over that finding, or a contrary finding can be given by the appellate court? Look at para 10 and kindly place it.
Even otherwise the petitioner having
Kindly speak to the microphone.
Miller. After resignation from
It is
the
not after resignation. Para 10 read something else, and they read para 10.
or even otherwise the petitioner having employed as DRT from August of 2012.
PRT don't make
Page
it.
number?
Clerk,
Page 29.
Go to page number 29. Even
Don't
otherwise.
stop, sir. Read kindly.
Have you got para 10 with you?
its engagement as Shiksha Sahayaka cannot be nationally reckoned from 2011 as it would be concerned with the period during
Sir, you are not reading.
Para 10 of the judgment judge.
Miller.
Go to that paragraph.
He's reading but adding some words. Then I have to read it. As it would coincide with the period during which he was already engaged as block resource teacher.
Miller.
It goes without saying that a person cannot be permitted to be employed in two establishments at the same time. In a case decided by the Honorable Supreme Court, that is the case of Jagdish Lal versus State of Haryana.
Miller. My
So then go back to para 9, just above. It is undisputed that the judgment passed by the coordinate bench in WPC 79 of 15 has not been challenged by the petitioner,
Res judicata.
though his claim was rejected. He has made another attempt only after said Sujata Rani Rath was granted the benefit. As such, this court holds that without asserting the judgment passed by the coordinate bench before the higher forum, the petitioner cannot be allowed to re-agitate the same issue only because another person was granted the benefit. In any case, the basic claim is to treat the petitioner as an appointee of the year 2011 in both written petitions. Therefore, the judgment passed by the coordinate bench would certainly operate as res judicata.
Miller. In WPC number 6479 2015, the petitioner was challenged the order of the collector, district magistrate, in which the collector has rejected
Sir,
the claim of the.
Sir, we don't require the background. We are not.
Then a claim of the
Sir,
petitioner.
can we concentrate on the subject you are addressing? You should argue the petitioner's case. Now, suppose, let us say that 9 would not be 479 would be not be res judicata. That is our para 10. That if you are already engaged in such and such post, then you cannot be given another post.
I am not claiming the reckoning my service since 2011. I am paying for reckoning my service from the date of my joining.
Which post?
And 2013, August of 2013.
So your prayer. Then it's a good.
But single judge proceeds as if he wanted it from 2011.
Gracias, please to the opposite party. If the opposite party to fail show cause or show insufficient cause.
That's not important, sir. You prayed before the single judge.
Pashmate of order.
So
Let us see that order dated 23/8/24. That order you have shown now. What you had challenged before the single judge.
I am not challenged, but
open the writ petition.
Open prayer of the petition with the opponent in the petition. Let us see what he had challenged. Go to prayer column.
That's not the prayer.
Miller.
That's not the prayer. Page 16 of the writ petition.
Miller. Directing the opposite party number 1 to, as per the terms and conditions of direction dated 2022 in WPC number 8705 of 2022. Miller, my claim is similar with the.
Consider him having been appointed pursuant to advertisement dated 23/2011. That is his prayer. All prayers are only drafted in this court. Most of your prayers are ununderstandable and run contrary to standard books of writ jurisdiction. Issue notice, if you note, after issue notice, if it is not satisfied, then you call for records. Then what kind of prayers are being made here? Issue writ of certiorari, questions.
Even my esteemed senior could understand. I could not understand anything actually.
Prayers column how prayers should be drafted, that decides the fate of the litigant. Issue notice, and if he does not show reply or send reply, or reply sent by him is unsatisfactory, then call for records, then issue writ of certiorari. What is this? We don't understand. Simple. Issue writ of certiorari, quashing impugned order. Issue writ of mandamus, directing them to do this job. Consider my representation. What kind of prayers are made in this court?
So you are seeking a mandamus
Yeah.
in writ petition.
Yeah.
It's quashment. It appears to be quashment.
No, sir, quashment is not there.
In person, even that is very. At least we should understand. Of course, we are not bound by English law of writs. If we see the Constituent Assembly debates, the makers of the Constitution did not want English law of writs. Therefore, they used the word writs in the nature of. So, but we should know the nature of your prayer. What is your prayer? We have to pray God to know your prayer here. After comes, he may tell you. You take notice and tell us what is his grievance. We have not understood. Really, we have not understood. You can tell us. If possible, you can improve his case also. Take notice just. Why Learned Single Judge said that the matter is res judicata, I am unable to understand. Because his prayer in that writ petition, again, if his prayer is that writ petition has to be seen. Earlier one. Issue is Learned AG on request accept notice for the all official respondents.
No, not private respondent.
For the official respondents. Issue emergent notice to private respondent number 666.
And please collect all those writ petitions you have referred in your writ petition.
Because we may need all of them to know what is your prayer here. We can't appoint commission of inquiry to decide what is the prayer in the writ petition. Yes.
Item 7, my lord, I am appearing for the individual opposite party and I need a copy of the writ application. And the single order is already complied with since long. I need a copy of the writ application, my lord.
Your friend wants copy of the petition. Share a copy.
My lord.
Your opponent,
Yes.
friend,
Yes.
wants a copy of the petition.
We will give.
Appeal memo.
Yes, ma'am. And this is an appeal preferred within the statutory period of limitation.
Yeah.
Date of the judgment passed by the Learned Single Judge, and it's an intra-court appeal where the eligibility of a candidate who has ultimately been selected and enjoyed the fruit of the employment is under challenge. And you will also say this here is a case where a person who did not submit any certificate in support of his eligibility by the cut-off date having been issued in his favor was allowed to be considered in the selection process and ultimately selected by taking into account the certificates which he obtained subsequent to the cut-off date. And the advertisement in question clearly stipulated
But after that, nothing will be looked into.
and it will be rejected summarily. And my lord, all those, the application should necessarily contain the documents in support of their eligibility. That is also exactly
Where is your advertisement?
my lord, here I am handicapped, my lord. I beg apology for that because it is in vernacular. So
No issue.
No,
sir.
it's all right, brother knows.
yes, ma'am. Your lords, your lords may kindly come to
You are referring to writ petition or writ appeal? Sir?
writ appeal.
Writ appeal is there. It's
Yes.
there. The advertisement is there.
Yes, my lord. Everything is there. I have furnished the copy of the writ petition, copy of the
Kindly
counter.
carry on. Kindly.
Page 39, your lords may kindly come to. Annexure 1.
So,
Where is that clause?
My lord,
If documents are not.
my lord, the third line itself. My lord, the third line itself. I will take your lordship to মানে থার্ড লাইন দরখাস্ত গ্রহণের শেষ তারিখ 4/2/2010. The last date of making application is 4/2/2010.
It's slowly. You are reading 39.
Page 39, third line.
Annexure 1.
Annexure 1 of the writ petition. That is also the entire writ petition has been annexed.
Last date is of the submission of the application is 4/2/2010.
আবশ্যক প্রমাণপত্রর সত্যাপিত নকল সহিত নিজ দ্বারা পূরণ করা যাইଥିବା নির্ধারিত ফর্ম ধার্য সীমা মধ্যে যেকୌଣସି ସରକାର ବ୍ୟକ୍ତିଗତ ଓ ରେଜିଷ୍ଟ୍ରି ଡାକରେ ପଠାଇ ଯାଇ ପାରିବେ। ନିର୍ଦ୍ଧାରିତ ସମୟ ସୀମା ପରେ କୌଣସି ଦରକାର
In the prescribed time,
yes,
if you do not produce, it is that way.
yes, and it has been clearly mentioned ନିର୍ଦ୍ଧାରିତ ସମୟ ସୀମା ପରେ କୌଣସି ଦରଖାସ୍ତ ଗ୍ରହଣ କିମ୍ବା ବିଚାରକୁ ନିଆଯିବ ନାହିଁ। If any application is received
Subsequent to this cut-off date, prescribed date,
it will not be entertained. Moreover, your lordship may kindly come to
Now, Lordship understands Odia also, you read slowly. Because I have not translated it.
sorry my lord.
So, but you are going through speed is always very high, sir.
many Sanskrit words are there, na? Therefore I could not.
My lord, it's a great pleasure if your lordship understands Odia.
It's a very beautiful language. Odia I should learn.
My lord,
Yes.
my lord, it reads my lord. My lord,
No, first point you have made it. No?
yes, your lordship.
Then how learned single judge treats this?
My lord, may I pray, my lord? One more line from the stipulation of the advertisement itself.
Yes.
My lord, next page 40.
Yes.
The clause available at ঢ অসম্পূর্ণ দরখাস্ত গ্রহণযোগ্য নয়। Any application
incomplete asampurna.
Yes,
incomplete
application will not be entertained. That is the clear cut stipulation. And the next paragraph, the stipulation, your lords may kindly see. My learned senior will have his say on this. That is why I am pointing out. But the cut-off date was 4/2/2010, and the date fixed for certificate verification was fixed to the very next day as per the rules. Rule says one has to apply within the stipulated period, and the date of verification will follow the very next.
Produced all these things subsequent to cut-off date.
There is also a reiteration of the very same clause. Why I say so? It reads like this. ता 5/2/2010 ରିଖ ପୂର୍ବାହ୍ନ 10 ଘଟିକା ସମୟରେ ସମସ୍ତ ଆବେଦନକାରିଣୀ ସେମାନଙ୍କ ଦାଖଲ କରିଥିବା whatever application they had submitted ପ୍ରମାଣପତ୍ରର
Certificates.
all these documents which they had submitted along with their application, they will bring their original and they will get it at the time of certificate verification. That was the clear stipulation available in the advertisement. Now your lordship may kindly see the person who has been selected.
He produced on which date?
Well, that I am showing to your lordship the very documents itself. Page 190.
We believe you. Can kindly keep the date.
Page 190. 5/2/2010. Their certificate was obtained. My lord, there are
Even they are obtained after the cut-off date.
yes. Your lordship may kindly say two things, my lord. That person was selected in the selection fray on account of two grounds. First of all,
Only have made a case for issuing notice.
why I am saying,
Well, after issuance of notice, what will happen? I don't want that we should issue notice or what?
We have a case for admission. This is not hearing. Admission, some point has
yes,
to be made.
yes, my lord, yes, my lord. Only thing your lordship that when this document was obtained.
No, Lordship has answered your that it
I
was
answered your question.
obtained, after cut-off date. You have to be
Not in the very next day, a certificate which was furnished 5 years after in support of his caste, that was considered to give him an additional age of 10 marks, which made him to the select list. Ultimately, he got
the
selected
selection process waited for 5 years.
because there was some stall of operation of this selection process. Thereafter, all the certificates were reconstituted by making a notification, and the selection process ultimately was made in the year 2016. Advertisement is of the year 2015.
That's all right. But when it comes to caste,
Yes,
caste is by birth. The Indra Sahani says,
but he
is by birth, those certificate is issued subsequently.
certificate at all.
No, there is other point which my brother
Yes,
said.
yes.
Not only caste, otherwise you would have said, Lord Krishna says in Bhagavad Gita.
No,
the
not
caste. This is quoted
Yes.
in one of the judgments.
Yes.
Yatnam Kule Janma, Purushayatnam Paurusham. Therefore, in which Kula you are born is decided when you take birth only. Right. So even if certificate is issued subsequently, that will relate back to the date on which you are born in a particular community. Yes. But what my brother, esteemed brother says is, it is coupled with income also. Yes. That is the reason time will be a factor. Yes. Therefore, you should not argue more. The judges are convinced.
So you never know which judgment my esteemed senior will cite. So where we go? Which SC, ST or SCBC?
SC.
SC, then the Lordship is right.
No, I don't see it. There, my lord, my issue
SC means once born, it's...
no, my lord, I am still going to the stipulation of the advertisement.
Today, Mr. You have over-argued or argued for Mr. Mishra. Now you are arguing for Mr. Mishra.
Caste it is related to residence, your lordship. No, 5 to 2010, the
residential certificate.
Yes. That is, he didn't submit either of the certificates, neither of the caste nor the.
Your case is that within the update, he did not produce any document.
Yes.
And those who have been produced subsequently have been acted upon and he has been granted this.
Yes. Yes.
Mr. Mahapatra, you will also argue, or you are satisfied with Mr. Mohanty?
The same point, my lord.
Same point, sir.
Because two read applications.
So please,
yes.
Rather, your point is behind.
No
problem. Then you can spare us. I'll issue notice in both the matters. A state is a party.
Yes, state is a party.
1 to 5. Mr. Mohanty, learned AGA, on request accepts notice for official respondents. Emergent notice to private respondents.
Mr. Mishra, you are
only one person, he can.
Private respondent.
He already appeared. He has already appeared.
You are private by the
No.
Just give us a moment because he may not hear you. Mr. Mishra, you are appearing for Minati Naik.
Yes, ma'am.
Your learned instructing counsel is?
My lord, A. Mishra.
A. Mishra. Mr. A. Mishra, learned instructing counsel appears for the respondent number 1. The learned senior counsel, Mr. K.P. Mishra, is instructed to has been interested to appear on behalf of the respondent number 1. Let 2 extra copies of the writ appeal petitions be served on Mr. A. Mishra, the instructing counsel, in both the appeals. 1 order or 2 orders?
You can print the same order.
Same order in both writ appeals. Mr. H.N. Mahapatra in the second one.
3178. We can call these matters together.
Yes, your lordship.
Call the
same one.
Listed that way only.
I
have filed on IA.
Both the directions, both the matters will be listed together.
I have filed.
Yes, when you want, agree for a date. Mr. Mishra,
since he appears, my lord.
Select the senior. It's a courtesy.
In 3 weeks, my lord.
3 weeks.
Yes.
12th of August.
Short point. How Apex Court has treated these aspects?
Yes. I have
that judgment you have to bring.
I have already enclosed, that is part of the record. That is already part of the signatures.
I have filed one IA.
12th August on concept is 12th August.
AFR?
Operation of...
Already order is implemented.
He has been working.
My lord? Yes. He was disengaged. Challenging that disengagement order passed in the appeal.
We are asking you, how long he has been working?
Recently, my lord, after the judgment was delivered, he was taken in service.
Let us see. Nothing. Anyway, if you succeed, you will get that point. Then he will go out.
It is submitted by the learned counsel appearing for the appellants that the respondent number 1 in both cases.
Yes, sir.
Respondent number 1 was disengaged. Still challenged the same by filing appeal. By filing appeal.
Filing the writ petition. Filing this writ petition.
Appeal was in our favor or against her?
It was filed by the client of Mr. Mahapatra. In that appeal, Mr. Mahapatra succeeded. That resulted into disengagement of the other person, challenging that disengagement.
Just give me a moment. Mr. Sahoo, call it.
That respondent one in both the cases was disengaged.
Pursuant to the order passed in the appeal. filed by the petitioners before the ADM.
Yes.
Before the ADM. The order of the ADM was challenged in the writ petition. And thereafter, after the order, or judgment and order, he has been re-engaged.
9/10/2024 is the order, impugned of this order.
That's what.
He has been re-engaged on
30th 11/2024, my lord.
2011-2024. Is observed that engagement, continuance and engagement of the respondent number 1 shall be subject to result of the writ appeal.
Item 8.
May I please, madam?
Yes.
My lord, this is regarding grant of NOC for a technical education, that is BSc course.
Mr. Mahanti, everything, you are freed of that much of.
Yes, nursing.
So you are granting it in some cases or not?
No, we have not yet given. So we are making it. I have made for instructions. The cases, what are the cases? What is the real problem which can be solved? Where this cannot be solved, we have to go for counter and making it. There is a notice book.
I have solved the copy.
So for the issue notice,
One extra copy you serve.
yes. State is warranty for the which respondent?
One.
I'm for the respondent number 1.
For the first
One.
respondent, appears for the respondent. The net panel counsel appears for
2 and
the
3.
2 and 3.
2 and 3. Call this matter on a
1 week after matter, because for whatever is happening tomorrow.
Tomorrow is there are 7 to 8 cases tomorrow. It is
different cases, similar cases are coming.
Yes.
Can you have it next week?
Can you
Yes.
obtain instruction on 7 tomorrow, right?
Let me see, otherwise let it come next week so that it can
So that
be.
we can pull all the matters and cases. We'll call this matter on the 5th of August.
Yes, ma'am.
Next week is 30.
No, the other matters are coming. We can pull all of them. Admission. Matter on 30th of
August under the same head. Sorry, 30th of
July.
under the same head.
Under the same head.
My lord, one submission, my lord. My learned brother should take instruction as regards annexure 6 only.
Pendency of the writ petition shall not be the authorities to consider the grievance raised in the writ petition, and if so, that can be the result of
Can we consider?
Consider the case of the petitioner.
That's how.
And take a decision in accordance with law.
Item 9.
May I please, Your Lordships? Your Lordships, here I will be permitted to withdraw the content because the application has complied, Your Lordship.
The net counsel appearing for the complainant submits that the order in question having been complied with, the case be disposed of accordingly. First, we agree. Ordered accordingly and contempt petition is dropped.
Standing counsel is present.
No.
Not short copy. The memo is taken on record.
I have informed them.
To be quoted.
Memo can be
For the petitioner. So petitioner or complainant, what do you call the content petitioner?
Petitioner. Notice to so calls. So petitioner.
Petitioner has filed a memo dated 23/7/2025 seeking the board to withdraw the petition. First, memo reads as next paragraph. In view of the above, petition is disposed of as having been withdrawn.
Obliged, Your Lordships.
Item 10.
Wait, please, Your Lordship.
It's a intra-court appeal. And there is a delay of 106 days.
What is the explanation for delay?
Because that has been communicated to the authority and the same has taken the approval of the authority for which certain delay is caused.
Yes, brother, delay we shall condone.
Yes.
On merits we will look in.
Yes, I am for the respondent. But short matter is whether unutilized leave salary can be released in view of the pendency of the criminal case or the vigilance case. That is well settled by the apex court. If there is no rule to that effect, they cannot withhold the unutilized leave salary. Two Supreme Court judgments.
The point to be decided, madam.
No, that is there already.
Only non-sanction of the unutilized leave salary. While there is a petition,
I don't find any counter. Where is the counter?
on the first day it was disposed.
Correct.
You lordship, detailed
4/12/2020. No counter.
the judgment is there itself. Kindly have a glance to detailed judgment.
In the read of proof.
No, Mr. Bali, the problem is we have to attribute that they placed something on record. For that appellate court, how we can attribute it now? We cannot.
Jitendra Kumar matter. Jitendra
Yes,
Kumar.
state of Jharkhand versus Jitendra Kumar Srivastav and Hiralal. Subsequently, Hiralal that relied upon the Jitendra.
And Odisha has a circular.
Now that circular cannot take the way of rule, substitute the rule. That they
Absolutely correct proposition.
there is also circular.
Kindly listen. Jitendra Kumar, kindly read the last line of Jitendra Kumar. It says either there has to be a rule or a guideline or a circular.
No. I am supplying the judgment.
Kindly read Jitendra Kumar.
Kindly have a glance.
No, you did not. I am having all the judgments. Jitendra Kumar, you read.
Yes.
That is the request.
Yes. The para two, CRIFs and short procedures for consideration in these cases is to have to whether in absence of any provision in the pension rule, the state government can withhold a part of pension, any or gratuity during pendency of the departmental criminal proceeding. The High Court has answered this question with the impugned judgment in the negative and hence directed the appellant to release and withhold. There they come up with a circular.
Can you read further? Where it has dealt with that in circular, suppose a circular is there.
Yes.
Then what would happen?
Yes.
That can be done. That single judge has said circular has no force of law.
Yes.
But
Our division.
while disposing this, I have not been given a chance.
There is a division bench.
Statutory nature of the circuit. Because in Bijo Emmanuel,
Yes, madam.
a circular is not a piece of legislation unless it is relatable to some provision of law.
But so far this office of 2015, that has not been taken care of while disposing.
No, but now we.
Yes, madam. Therein it has been specifically contained. And
But it cannot take away rights of the city.
in absence of the specific rule, only that is the way.
No.
But that is in 2000.
We have 86 of them. That was the argument. We have official circular.
Official.
And therefore we have justification. Apex court said we cannot.
In this division bench judgment also taken care of the same issue, leave encashment issue. Our Honorable High Court Division Bench. Yes.
But we have not been hard, nor we can press the same. Except that official memorandum, that only speaks about
Division bench judgment of this Honorable Court.
It can silence the rights of citizens. They have power to issue executive instruction and memo. But as long as they do not come in the rights of the citizen, this is what video manual is.
The same issue is taken care by this division bench. Yes, sir.
Very hard by our senior. When judges are in your favor, even if they are wrong, why? We will report that. Maybe our seniors were wrong. They have consulted you. This in front of the being state, any piece. In the state. Why not? Single volumes will be. This following respondent in the volumes would be numbers weight to in favor. A direction will be given for releasing the leave. Next part. Learned the AGM will be paid for the employment. Service that the reasonable opportunity or to have been awarded whether it is legit. Consider the matter at a bit deeper level. There is miscarriage of justice warranting interference of appellate court. First one. Learned counsel appearing for the employee resist the appeal, making submission in justification of the impugned order of the learned single judge and the reasons which he has furnished in support thereof. First, he also relies upon the apex court decision in State of Jharkhand versus Jitendra Kumar Srivastava. Citation. 2013. 2013 SC 3383, which learned single judge has referred to in the impugned order. First off, he also places upon he also relied on he also relied upon Hira Lal versus State of 2020 2 SCC 4 SCC 346 in support of his contention that by circulars and memoranda, the rights of citizens cannot be silenced. First one. Next paragraph. Having heard the learned counsel for the and having perused the petition appeal papers, we decline indulgence in the matter, being broadly in agreement with the reasoning of the learned single judge that the terminal benefits of an employee constitute his property, right to which is constitutionally guaranteed under Article 300 capital A, after the said right sees it to be a fundamental right under the provisions of Article 19.1. 1901 after 42nd Amendment. 42nd Amendment. First, if claims of the kind constitute property in its generic sense, comma, retaining that property of the citizen by the state amounts to appropriation for which statutory authority is necessary. First off, such an authority is not placed before was not placed before the learned single judge, nor it is placed before us here. Next paragraph. The vehement submission of learned AGA that the learned single judge grossly erred in overlooking the circulars, saying that they do not have force of law, comma, is difficult to accede to. First time. The benefits of the kind can be withheld only if the instrument which gives power to make such a withholding has a force of law and not otherwise. First, proviso to Article 309 of the Constitution provides for rulemaking in terms of service of the employees of the state, inter alia of the employees of the state. First off, no such rule is brought to our notice. First, a division bench of a coordinate bench of this court in WPC number 3442 of 2016 between how you are which sir, actually first page you are not given first page at all between so and so and so and so has considered
first page
and rejected contentions which Mr. Mohanty had placed before us. Yes, before us. First, we also agree with the observations in the said judgment, which include non-giving of opportunity at the hands of the learned single judge as well. First, in the above circumstances, this appeal being devoid of merit and also filed after a long delay of 100 odd days is liable to be rejected accordingly, and accordingly it is being been made easy. That front, you have to give that front page of the judgment. Yeah, bring that and give it to. If you print it after he gives, otherwise don't print the judgment at all.
I go straight to continue. Item 13. Item 13, my lord, kindly draft to last order, my lord.
Still, my lord, on last occasion, my lord has been pleased to direct that the abnormal delay of 1,035 days, that the amount of rupees 10,000 is to be paid. Of course,
you are paying it now,
but that is not paid, my lord. No, that is within the period of 2 weeks, my lord. That is the order.
2 weeks.
Take that money. When money comes, you should simply pocket it.
And if it is charged, it will be 1 rupee more.
With a copy of tea, that will be compensated. That copy can I
learned?
Yes,
Learned AGA, Mr. Mohanty, has handed a bank draft for a sum of rupees 10,000 in terms of our order dated
2/7/2025,
whereby application for condonation of delay was favored, subject to the condition of paying this sum. First of all, thus the requirement of the order is complied with. Yes.
On merit.
Yes, on merit, my lords. If they are ready, my lords, I am also ready, my lords.
This what is this? 2024 matters. There are older matters, right?
Next week, my lord, because
Let us see. There are very older matters are there. No?
because in that 2023, my lord, she retired, my lord, she is not getting the pension. That is because due to pay revision, my lord, she is not getting
The
less.
differential he is not getting.
Different.
He is getting.
Yes, pension is getting in the old pension, my lord. That is
That amount which has been wrongly fixed.
The third week of August 2025.
my lord.
20th of August.
20th of August.
Item 40. It's an appeal by the state where involving 169 days of delay. 169. The kind of considers.
Will condone delay, brother. On merits, let us see what.
Yes, ma'am.
Lordship is filed with a delay of 169 days. First off, an application supported affidavit is moved, seeking condonation. First off, delay is short, condonation offered is plausible. First off, in view of the above, application having been favored, delay is condoned. Yes, sir.
Mr. Barik, you have to mention the case number because we do not know in which matter you are appearing.
Let's see the tagged matter. I am for the tagged matter. I was appearing the tagged matter 9879, WPC number 9879 by 2016, which has already been disposed of by a single bench. But the problem is that we filed an interim application to revive the matter, Millard, and that has not been heard yet. And now because it has been tagged with this writ appeal, then we want that we should also be heard while the writ appeal is heard. And I don't...
Or seek leave. Then appeal, suppose you are not a party. You want...
No, they are party.
Whatever. Achha, they haven't met party.
They are parties.
So, Barik, you are a respondent number?
1 and 3.
1 and 3, my lord.
1 and 3 in the rate is... 1 is state.
No. Lordship, respondent.
The respondents, my lord. Those who were the petitioners in the original writ application.
Mahal, M.S.Sahoo.
Yes, Lordship. Yes, Lordship. Because
Just give us a moment. Kindly listen to the order.
Okay.
Mr. K. Barik, Learned Counsel appears and submits that in WPC number 9879 of 2016, the respondent numbers 1 and 3 are the petitioners. The said writ petition has been disposed of by the learned single judge, and an IA has been filed for reviving the said writ petition, which is pending consideration. Stop. In the writ appeal, the respondent number 1 and 3 are, you will file your wakalat?
Lordship.
You will file your wakalatnama on behalf of 1 and 3.
Yes, Lordship. Some time should be given for that because I am away from the station.
In this case, what has happened? Relief has been granted to me, and their case.
But since already he has raised that issue that he needs to be heard, and he is a party who have made them a party. Those are copies. Account sentence. It is stated by Mr. Barik that he will represent respondents 1 and 3 in the writ appeal. Learned Counsel for the appellant shall serve 2 extra copies.
Yes, sir. Appellant state.
Learned Counsel for the Learned AGA for the appellant shall serve 2 extra copies of Barik for R1 and 3. How much time? You have any learned associate here who can receive it? Present in court today?
Not today, my lord.
Mr. Ponda AGA. You can see him in the VC?
Yes, Your Lordship. Once I am at Cuttack, I'll within 2-3 days. Then just next week. Next week.
What has happened in this case? Honorable single judge has allowed 3.
No, I'm asking you, when do you want?
I am wanting Lordship next week because
next
I will get
the third week on 20th August. Okay.
20th August.
20th August, Lordship. Okay.
Yeah.
Next week is
the copies from Mr. Ponda.
Yes, Your Lordship.
Item 15.
I'm pleased, Lords.
Yes.
This is intra-court appeal wherein 12 days delay, my lord.
Only Matter on merits. Your opponent is there already.
Lordship. It's a Gridco. Come on. You should have a panel. We have notice to do. Notice to do.
Anything on merits?
Anything on merit, Mr. Mahapatra?
Lordship.
Please address.
Lordship. Challenging the order of the Honorable Single Judge, wherein the expunged petition has been rejected by the authority. Challenging the same, the
Expunction of adverse remark.
Your Lordship.
Notice effect.
Issue emergent notice.
On IA as well as the appeal.
Appeal.
Requisites
Within 3 days, Your Lordship.
within 3 working days.
Your Lordship.
All are official opposite party Gridco.
Yes, Lordship.
Next.
Hon'Ble, Your Lordship.
15.
So Mahapatra, one question. Gridco is still there or it has been subsumed by some subsequent entity? Grid Corporation of Orissa still remains Grid Corporation or it's a
Tata Power.
Gridco is now Tata Power also. You can verify and
Your
if
Lordship.
it is there, file that memo and go to
Your
the
Lordship.
court master.
Your Lordship. Will verify. Hon'Ble.
Yes, same order. But say যদি দেওতি মেমো তাহলে সে নিউ অ্যাড্রেসটা দেবে।
Hon'Ble.
Otherwise it will
It will never be served.
Yes, sir. Last occasion directed to serve paper book on Mr. Pilland. Respondent, I am serving the paper book.
Okay.
Read petition, counter and rejoinder, etc.
Full paper book is given now.
Yes.
Yes. Then what?
This paper book doesn't contain your counter for and rejoinder and further affidavit.
Both side print. Printed both side.
Compassionate appointment.
Yes.
What the direction now?
Direction, my lord, that it was delayed. The allegation was it was delayed for 2 years. And appointment was given. But the direction was from the beginning, you give all the benefits. Compassionate appointment, they say that it accrued 20 years before.
So 20 years salary and other things to be paid to you.
I don't get any salary, my lord.
No, you were not appointed at all.
No, man, I have got appointment in
You were appointed.
1992. My father died in 1988.
1988 is
I applied for compassionate appointment in 1989. Then my application was sent to the director for consideration, and director returned it to the governing body with the remarks that if any vacant and approved post is available, then he may be given an appointment.
that was when?
That is in 89.
89 itself.
89.
Page.
Documents are there, my lord.
Page, director's letters page. In writ appeal or writ petition, you can show both. Writ petition. Writ petition da column.
Actually, which date you were appointed?
Pardon, ma'am?
Which date you were appointed?
I was appointed in 6/6/1992 and I joined on 12/6/1992.
You have been working.
And since 1990, continuing as the post, and my appointment was sent to the director for approval. Then they kept it pending till 2012. They didn't do anything. In 1996, I filed a writ petition for a direction to take action on my appointment for approval. They didn't take any action. Then this honorable
When you are
court,
saying they, even who?
the state government, the director had
Is a appointment under the state.
My appointment order was submitted to the director for
You got appointed under which authority?
by
the authority.
governing body,
It's a private entity.
aided educational institution,
Governing body.
governing body.
So who is to pay? Government is to pay.
Government is to pay on the direct payment system. That is why, my lord, my appointment was sent as per the direction of the state government.
What was the rules governing then in 89? As you say, it is from
89, my lord. I was appointed in 92. In 90, the rules are been.
What was the rules in 82? In private aided colleges? Suppose one takes appointment because this assistance rules is for the state government.
State government. And it was given effect to, my lord, from 1990 by the GA department. These benefits were given, extended to the aided education.
Non-government aided colleges.
Pardon, my lord?
Non-government aided colleges. It was extended.
Aided colleges.
It has not given to college. It has given to all educational institutions, aided educational institutions in general. So college comes within that aided educational institution with effect from the 1990.
He has worked in the post. Why you kept quiet for so many years? Therefore, he had approached the court.
But he's saying that he's 92, but the Annexure 6 at page 16 reflects. Lordship, okay. Annexure 6.
Annexure 6.
Read petition.
And then Annexure 6.
At page running page 16.
2013. So according to you, which is the earliest letter that can fortify his appointment or can be the evidence of his appointment for you to give the benefit?
It's showing all throughout 13 minutes.
14/1/2013. No, this is assignment of duties. Before that, which duty your client was doing, sir?
Before 13, you come to.
I was serving as the demonstrator in zoology department in the college.
No, you were a junior clerk.
Junior clerk. Annexure
430.
Annexure 1.
13. It also says junior clerk. 30. Now देखो 13 को जाते
storekeeper.
That one. So enhance करो तू.
Especially Annexure 3, it is also 2012. Appointment under rehabilitation assessments in the non-government aided college.
That is under challenge. That was challenge that has been passed.
47/12/12.
Earlier, another Annexure 1. Go to Annexure 1. It shows storekeeper. No, if you are appointed pursuant to resolution dated 6/7/88, how is that you for duty only on 12/6/92? You are directed to report for duty within 1 week. Go to Annexure A1. If some doubt arises as to the authenticity of these documents.
Sorry, A1. Annexure A1.
Annexure A1. You were appointed by letter dated 6/7/88. And resolution dated 2/1/89. You were directed to report for duty week.
Actually, A1 kind. A1.
Annexure A1.
Scroll down कर ले पेज का तुम्हारे Scroll करो तो Scroll करो तो पेज टा जब घुसे ଆପଣ ପାଉ ପଳେଇବ page 9 of the writ petition.
Page 9. It's your document.
Looks at 1.
Yes, Annexure 159. Institution standing blows.
Annexure 1, my lord. Annexure 1, my lord, that I got in 1992.
89 the resolution lekha hai na resolution.
It says within 1 for duty. Kindly see the text of the resolution.
ते पढ़ूं तो सब पर 1 रे पेज 9 रे सब paraटा पढନ୍ତୁ। 1 big.
Yes, my lord. He is directed to join within 1 week from the date of issue of this order. I joined on 12/6. Next page.
No, this is of which year?
92.
2189.
No, my lord, memo number 3, next memo.
So the
correct. On the, if the resolution was passed in 1989, how is that the appointment order was not issued till 1/6/1992?
Yes, my lord, I am explaining. My lord, just 1 minute.
has to get the
affidavit.
So Rautre, kindly get the dates, mark the dates in Annexure 1. Second line, the date, and the last line, the date.
Further counter affidavit. Further affidavit tadir kai. Further affidavit. 688. Your lordship may see
After 3.5 years,
further I will add a copy to there.
you recover that money from the management.
My lord, actually, I am giving the copy documents, man. Further,
If money is due, recovery from the management. Why state you should give it to you?
Last page. Description of the. That's all there. Shipment 6. Taku the government ko gote copy de. Mate gote copy de. Further, the government pay ka gote copy de. The lordship may see in that read petition I have filed on further affidavit.
They are already, we are having that. Page
89.
Page 32.
Annexures, Annexure 8.
No, actually, that doesn't answer that Annexure 1. Further affidavit doesn't answer those dates. If you look at Annexure 1, first line is 89, last line is 92. And it is all, anyway, it's not marked at the top.
89, my lord. The director has said to give appointment.
That is the posture from the court. Please mark the language and the date in Annexure 1 of your writ petition.
Date is 1992. I got appointment.
No, resolution. And you were asked to join within 1 week in 92 after 3.5 years. That was the question.
Yes, I have joined.
After 3.5 years.
Yes. No, not 3.5. Your lordship may see the Annexure 7, last annexure in further affidavit, the resolution of the governing.
You are actually, you also say the same thing. And you also consider that you did not join from 89 to 92. You joined only after that 92, 12 to 92, you are saying. That in fact.
89, your lordship may kindly look at Annexure 8, further affidavit.
No, let us get out of that one dates. Because Annexure 8 is not also any. Yes, that creates the difficulty.
Subsequent resolution, my lord, in 92.
They were running after you to get you engaged or what?
No.
So that's the so that is how the court asked you that if you look at Annexure 1, Annexure 8 also.
My lord, before that.
And also this 4789 and 1292. So everything is
I am explaining.
That those days are glaring.
My lord, I am explaining that, my lord. 4789, may I read it, my lord?
No difficulty. Nobody disbelieves 89. That
thereafter, my lord.
If you do not rely upon, suppose your contention is that there was no resolution in 89, then you may have some case. You are relying on the resolution dated 2189, maybe 4789.
Yes, ma'am.
So that doesn't improve that way. It still remains 3.5 years.
Yes. That in 89 last 2 lines, my lord, in case there is no approved post in the college to accommodate Sri Mahanti, nothing can be done to help him. For the present, there is nothing to be helped. And post remain vacant. One post became vacant So there is a next resolution in 92. After a post became vacant, then next resolution came in 1992, this 12/12/1992. Annexure 9.
What were the terminal benefits given to the employee who died in harness?
His father.
What is that you had given to him when he died in harness?
And the other difficulty would be, Mr. Datre, that order itself doesn't have any issue date and number.
And who is the competent authority to make appointment when post was not sanctioned?
In 1990 rules came, the governing body became the appointing authority so far as aided educational institutions.
But without prior approval of the government,
Without prior approval, you cannot.
Not prior approval, no. State will give the approval.
No, for creation of the post.
Objection of the court.
Creation of the post.
Creation of the post much before my lord.
When
the person who was holding that post, he died. So post became vacant.
When who was that person when he died?
We are talking about Sri Jadunath, who died.
Yes.
The father is father.
No, not father. He's saying another person.
Maybe that I was asking.
Whether your father's post you are claiming.
Jadunath died. His father died or any other person died? What do you mean to say?
My father was a doctory.
You are saying the
My
post
father died in 88.
because your post is also at times it is storekeeper, at times it is laboratory attendant, at times junior clerk. Actually, so who died? Doctor died. Laboratory attendant died. Storekeeper also died. Who died actually?
Both the doctor, my father died in 88.
Yes.
That storekeeper died in subsequently. It's further affidavit, paragraph 3.
How many of the other three posts where you claim to be appointed died? Or they also died? Everyone died in that college?
In that college, 2 persons.
About 4 persons, Mr. Samuddra, according to me. Storekeeper died, Daftari died, junior clerk also died.
Other person
No, if you are saying that, it is your submission. You got appointed because the person occupying that post died.
Yes.
So you have been appointed in 3 posts, apart from your father being Daftari.
I am not 3 posts, only one.
So look at
appointment designations. 3 designations are there. One is a storekeeper. Another you said demonstrator.
Demonstrator.
And yet another is junior clerk. Now it will be 4 died.
Junior.
Daftari died, storekeeper died, junior clerk died, and laboratory assistant or attendant died. Attendant, I think. Assistant would be a higher appointed.
Everything appears to be.
My lord, sorry, my lord, I am sorry. That annexure 1 is also a storekeeper. And annexure, this paragraph 3 of my further affidavit, I have also said that the storekeeper in the zoology department fell vacant. So I was given appointment in the appointment of a storekeeper. But subsequently, they have given me appointment and a junior clerk. Once I got an appointment as a storekeeper,
Working body can given the appointment.
The intimation to at page Annexure 1(9), what is the number and date? Look at Annexure 1, page 9. Mrs.
yes, my lord, page 9.
Top office order, no number, no date. Copy forwarded to
No,
director.
office order, my lord, because this.
No, you are not looking. The problem is that you are looking at me. You have to look at that page, what I am reading.
Yes, sir.
Kindly see that
Kindly look at
Annexure
that
1.
page.
Annexure 1.
Mrs. Lautra, you can point out the last one.
Yes, my lord.
No number, no date.
Next memo number which has been given to me, I am given the true
Correct, that's the
copy.
problem, sir. To ask them, then we can ask them that what is the response to the letter number and date. They don't have that copy. I hope you follow. Usually the top would be 366, last one would be 368. Could be. Or maybe it can be 3679, or because it has to be the number after that particular date.
It should be an increasing order.
Increasing order. So we do not know even to ask them that what is your response to that letter.
No response. That is why by this. No response.
Suppose, how do they know it? It has not sent to them.
It has been sent to them.
No evidence.
Where is
Next memo, my lord, copy forwarded to the director.
Correct, Mr. Rao. That is what I was asking. Number and date, can you explain?
No, my question is, if it is
There, my lord, the college has to give it.
if it is aided institution,
Indicated, they refer to that order. You now say that I got appointed in 92 after 3-4 persons died in their college, including your father.
Before that, this read also.
You can, that contention they have not taken. No, we are asking you.
Before this read,
Your salary should be paid by your employer. Is it not? Employee relationship obligation is with the employer to make the payment. Is it correct? Correct. In what way you are concerned with? The government is not your employer.
No, because they have to approve. Their only case is to approve. They are nothing to do with the appointment. The after appointment proposal is submitted to the government for approval, and once they approve, they have to pay the salary to the state. And if they have to refuse,
Now he can say.
But director never did approval.
Next to the writ petition marked as Annexure 4 refers to CONTC number 1073 of 2011 arising out of OJC number 1996 of 1997 into bracket Mahesh Chandra Mahanti versus State of Odisha and others. The registries are place both the records along with the present petition for reference.
Let them post that important material, then we'll see. We are still not convinced that you have any locus.
Released on 7th of August 2025. And one submission or suggestion to you, if you are satisfied from the whatever they have granted from 2012, you should not open the cupboards. It could be you have a case, but the problem is that the more you dig into that, more uncertainty and you get impacted by that also.
Since 1992, I am fighting.
Let us see. Let that document come. We'll look into that document also. Yes, Mr. Learned.
Yes. Lord, actually, I'm sorry. Your Lordship on the last occasion had directed the Secretary of Health and Family Welfare Department and the Director of Medical Education and Training.
Yes.
Item 38, Mila. 38.
Personal appearance.
Both the office. So we are filing it. Let it come some other day. It's very exhaustive. Your Lordship's concern, I also, my Lord, I am one with your Lordship because there is shortage of the doctors in various medical college and hospitals of the state. Two reasons. My Lord, one is there was no regular recruitment earlier. We have taken very prompt steps and have made requisition to the Odisha Public Service Commission, which is the recruiting authority, because these are all class 1 posts, civil posts.
Just give us a moment.
Yes.
We are getting that file actually. Move down.
This is a scarcity of hands in the institute.
What is the real difficulty what we are facing? Many of them are not joining in the government college cadre nowadays because many private medical colleges have come off. So I do not know, they would be doing private practice and all. We are permitting in certain things, but that is also one of the major reasons. Many of them are also offering for VRS and also abandoning the job. They want that we should be dismissed. Wherever we are refusing VRS, Millard, I am giving one example. Recently, we refused VRS to a particular professor of Berhampur. She did not want to move out. She is there for last 25 years, didn't want to move out. Immediately, she submitted a VRS. The honorable single judge rejected the writ petition. We refused it. Recently, the writ appeal has been allowed, directing us that you grant VRS to. So this is how, Millard, the government is facing enormous difficulties because colleges are more and the doctors are less. So therefore, Millard, but still then all tangible steps we have taken in the meantime for the process of recruitment to the base level post of assistant professor. It's a 3-tier cadre. Assistant, then associate, then professor. So all those associate and professor posts, they have to be filled up by way of promotion. There is no lateral entry. I was discussing with the secretary today that why shouldn't we also make the lateral entry like the All India Institute of Medical Sciences? So now she has agreed there is also in the rule 25% of the posts in the higher category, associate and professor, those posts are to be filled up by way of direct recruitment. We are also going to initiate that process. So, my lord, that is the difficulty. We want also the healthcare system should improve. Adequate doctors should be there. Hospitals should be manned by so those things are also the concern of the government. We are giving it top priority. This affidavit is very exhaustive. We are filing it today. This may be brought on record. If your lordship want me to address on this, let it be kept to some other day. Because today also your lordship is hard pressed, I was told. Let it come some other day. I will address on the issue. This is a larger issue. I do agree. We have to address it with utmost.
If people are not coming,
right,
it only reminds me of what a Japanese had told. Make your garden green, singing birds will come. If your garden is not green, no singing bird will come. You make your garden.
No, your lordship is absolutely correct. Garden we are trying to convert it to green. It was yellow. So now, gradually, in the process of making it green. So, your lordship, give us, we have to be given everything time to address that. Aptly said, my lord, I appreciate.
Why? So, every year, thousands of doctors migrate to other countries.
Absolutely, my lord.
Why? Because they are not duly respected, they are not duly paid.
True.
That is the reason. And if you want to pay peanuts, monkeys you will get.
No, your lordship is correct.
Only monkeys will get peanuts.
Still then, to address that
doctors.
Yes.
If you want good doctors, good teachers,
right,
and give them handsome, make
your lordship is
that way.
I am in one with your lordships entirely. I have seen in our, I should make this statement very boldly. I have been espousing the cause of the teachers for the last 1 year. Teachers who are supposed to be the most respected members of the community, they should not go and stage protest in the Bhubaneswar PMG Square, ask for salary and all. We are against it. Personally, I am against it. I have also been trying to impress upon the government. We will do away with this system of granting it. All those things are not known to a civil society, to a developed society. We are, my lord, working on it. We are working on it. Your lordship may give us some time.
Any affidavit you have filed now?
Yes, my lord. That is
whether
what we just passed.
The concrete steps.
Everything, my lord. Everything. It's exhaustive, very comprehensive. All the issues have been addressed.
Can we call this matter tomorrow? In the meanwhile, we will
tomorrow, my lord. I am happy. Any day next week or one. Any day. Fifth
of August we will have. But this is not to halt the ongoing proceedings. Whatever you have stated here, that
we'll carry on, my lord. We'll carry on. It is in the process. PSC, Public Service Commission, has already, my lord, issued advertisement. We have given appointment to 100+ teachers. There is no, that will continue.
My lord, may I permit to say something?
No, it's not her prayer. His prayer or something else, your lordship
issue we have taken.
Kindly listen to her. You are on this larger issue or something else?
My lord, the scarcity of faculty for their health system, my lord. My prayer is, my lord, according to the training program, my lord.
No, we understood. Because you see, there are
influence. So that will come to.
That we can address, and we understand why they have done. Because this maternity care and all these things that requires sonologists. Yes. That is how the court's concerned. If adequate number of postgraduate sonologists, that is radio diagnosis, is not there, is it that the healthcare should fail or they should train others?
No, I was
in our country, do we have that much of resources to get so many radio diagnostics? So your concern is well taken care of. You say that there should be adequate, for getting more
radiologists,
qualified radiologists by doing PG. In fact, there are some diploma courses also.
According to the notification, my lord, clause 11.
You cannot come in the way. You cannot come in the way for state granting of giving training.
That's correct. And
Can
to
it
the
be?
gynecologist, my lord.
Can it be? And at the central level, they are training the trainers. Senior professors are going to the center and they are training and they are training at state.
As
So
per the
they are
notification,
in that policy. I don't think, but this is a larger and
Other
bigger
issue is involved.
And if you want to assist, please go through and verify how it is implemented.
Share a copy of the affidavit with the learned counsel.
Already I have given. Already, sir. Already, sir.
Work on it.
Pursuant to our order dated 23/6/2025, the additional government advocate has filed affidavit of OP number 1, who happens to be the commissioner comes principal secretary to commissioner comes secretary, government of government health and family welfare department, and also director of medical education and
For
training.
two also, my lord. He's a government servant. He can't be represented by a private counsel. I think there is some confusion. DMET.
DME.
DMET
Director of
also
Medical Education.
represented by the state councils.
That's first off. Both the deponents are present before the both they have signed the affidavit. Only
Yes,
one has signed.
No, one and two both.
Huh?
That's the affidavit on behalf
Commissioner
of
cum secretary alone has signed that. No?
No, he can't appear.
my lord, DMT also filed.
Both
That's
have-
it.
DMET,
Yes.
my lord, is represented by the state council. There is
Both the
confusion.
officials have sold this affidavit.
My lord, I have been appearing for DMT and filing the.
No, DMET is a government servant. There is a confusion. He thought he's for some council, I think. You can't appear, represent a government.
But I have filed the counter. That's
No, you cannot.
Let
That counter I will draw.
us see.
Please don't create confusion
Yes,
in the
let
court.
us. Never done. First off. Learned AG, because it is on to only with the secretary. That we have to.
The counter will draw is president person.
The affidavit is sold to by the secretary, commissioner,
Secretary, Health and Family Welfare Department.
government of Orissa. First off, both the deponent of the affidavit in question and DME, Dr. So and so, are personally present before the court. These are the persons who are standing business. Can we see them?
This is Ashwati,
Yes.
CNIS officer of 2000 cadre, and he's a professor of the medical college cadre. He's the director of medical education.
Thank you for
and
coming here. Kindly be seated. We have seen them. We have seen them. Their credentials are given by the learned, and absolutely there is no doubt with regard to the same. First up, learned next paragraph. Learned AG seeks some time so that the implementation of what has been projected in the said affidavit before us takes effect. First up, with that understanding, matter stands adjourned to 5th of August 2025. First up, if any shortfall is found, the same may be made good in the meanwhile.
Diplomacy. Let the personal appearance may be dispensed with. If they are
Personal appearance of the said officials in the subsequent dates of hearing is dispensed with. However, if deficiency is found, their personal appearance may be redirected.
I am there.
Let us. Generally, we will not call the officer.
Desk.
Because apex court said in a half a dozen judges,
Yes.
officials should not be
Recently,
called.
the UP judgment has.
That's true. But there are about three to four exceptions.
No, that's.
This case fits into one of such exceptions.
An errant officer, my lord, will not spare. Your lordship may have that much.
Not errant. That errant. We have said that
They are very
errant.
My lord, I must put on record a word of is a very, very sincere and diligent officer.
That's very good.
And I have been working with them for last 1 year in tandem. So sincere, we have been taking real steps, my lord, to address this issue. It's a genuine issue.
Because apex court said,
yes,
India does not want half-baked doctors.
Right.
Right. Half-baked doctors will kill people.
Right.
Therefore, we are very serious about that. And you have given an assurance to the UN saying that we will provide health facilities to the masses. How are you going to do that? That's the reason they have called these officials to say that
And for the time being, their personal appearance is dispensed with.
Deeply.
Yes.
Item 18. Item 18.
On behalf of S.N. Biswal, due to illness,
Call after 3 weeks at the request of Learned Counsel Sri. Yes. Recollect.
Item 19.
judgment dated 10/1/25, 70 days delay.
Notice is not served.
Not sufficient.
Not served.
No, sir. He's suffering from cancer. 70 days. 70.
Petition.
That judgment 10/1/25 by my lord, your lordsman.
This is item 30.
10/1/25. That's right.
22.
That's right.
22. Sorry.
10/1/25.
25.
I am not party to the judgment.
No,
mother
your
is-
lordship, my lord was party.
So according to you, scope of liability,
Yes.
the grounds of review,
Yes.
does it satisfy liability?
Yes. That I'll come. I'll come. I'll come.
You may have a very good case as far as appeal is concerned. But as per the Supreme Court decision,
Review is restricted.
review is very restricted.
I'll come and solve a copy. I will speak.
So that doesn't help. I mean, that prolongs the litigation for the employee.
Should I hear it tonight?
See, they will happily accept and they will again argue that review is not maintainable. But for the employee, we must satisfy the criteria laid down by the Supreme Court in Maruti.
Should we hear it tonight?
So that's what being asked to you, that
Yes.
according to you, which aspect satisfy the test laid down in Maruti?
This has come. This has
Have you
come.
examined Maruti? Those 4-5
Only I've seen.
oh, you have to.
Lordship.
Look into, then come back.
Kamlesh Verma versus Mayawati.
I've seen.
Citation range. 2013. AR 2013 is zero.
Just look into and come back.
Because if this review is kept pending, issuing notice, the particular employee would be under impression something would happen. Because review is so limited,
Your Lordship is skipping it on.
We are giving 2 weeks time.
Today we can dispose it of, but we are giving you time for your satisfaction that you look at and make out a case as per as the criteria laid down in Kamlesh versus Malik.
Second week.
Second week you want?
Second. 8th or 9th.
9th is the Saturday. 8th of
7th or 8th.
7th. 7/8/2025 are the instance of the review petition. Well,
Item 23.
In this case, only correction of the read petition number that is wrongly typed in last order sheet dated 15th July 2025. Read petition number 2024 instead of 2025, it has been written 2024. Only. That's why the matter is. Order dated 15th July 2025.
Number 3. Top of the page.
WPC number.
Should be of 2025.
Registry to learned counsel appearing for the Union of India submits that in the cost title, the number of is wrongly printed and therefore it should be rectified as WPC 15519 of 2025. First off, we agree.
The matter is please to run 6.
We listed on the as directed.
Already that is there.
Registry to effect rectification of the order.
So don't correct them. If they should some us. That's corrected as per order.
The last line necessary. We have different lessons. We direct the registry it's been once. Then begin. Same thing.
The MA 1258 of 2025 is likely to be listed on 25/7/2025.
96/25 against the condonation of delay by the Honorable Supreme Court, they have filed the MA.
But it has been remanded, sir. The difficulty is that order is a remand order.
Yes.
The order has been passed in absence of counsel for respondent matter. Therefore, MA is pending.
No, please appreciate what has happened. You know the entire thing. What has happened? This is a batch of cases which have been disposed of. And the counsel were heard in that matter.
But separately in this case, separate order has been passed, my lord.
Then the back.
No. It's a no. It is
No, it is separately.
so many matters are carried to the Supreme Court. And
My lord, this is the order I have.
your lordship,
This is the order, my lord. Delay has been condoned in absence of counsel for a respondent, my lord.
With the order, judgment has been referred by the Honorable Single Judge, that has been pending before the Supreme Court also. Patitavan, the case. Yes. That's last 25th, I think 20th May or 18th May, I have by order by it. So that.
So we will done this matter by 3 weeks.
Yes, please.
So that's why it will be considered.
Yes.
So that is deadline.
No.
It is
In Patitavan, that case and batch of the data entry case.
The direction funding the matter.
That is High Court will proceed with the hearing of the office.
In this case, the direction was to follow the ratio decided in case of Umadevi versus State of Karnataka, and thereafter.
You are mistaken. You just read the judgment. They will
To enable the appellant to move the High Court,
My lord.
the interim relief granted.
My lord.
And then suppose you lose in this state appeal.
My lord.
Still, it is open for you to go to Supreme Court.
My lord. The order has been passed in absence of us, my lord. That is the. Therefore, we have filed the.
What Supreme Court has said. Whether you are present or not, that is one way of looking at it. But that's not every.
Well, kindly have a glance to para 1, my lord.
Kindly read.
Even on second call, none appears for the respondent.
It's not this. You don't appear. Fair enough.
Well,
That is not a. You cannot take advantage of that. After notice being sufficient, you did not appear. Then leave is granted. Look at the order. Don't.
My lord.
The detail of the part of the appellants not required to agree with preferring the appeal has not been controlled by the High Court.
My lord.
Where is the amendments made in the application for condonation of delay?
My lord.
Sufficient cause was made out to condone the delay. Accordingly, the appellant should assent. That one.
Due to our non-appeals, our image.
The ground that you chose not to appear. It's not that you are not heard or you could know this.
Therefore, we have filed MA number 5.
Even if on second call.
I wanted to bring to your notice as a counsel.
My lord.
How you are not the cause of the respondent also from whom you are appearing.
My lord.
This will not help.
I have intimated this thing to the my.
Can you look at 6, the next one?
My lord.
6 also read.
My lord.
Not minor. Paragraph 6 over where is not minor.
To enable
the appellants to move the High Court, the interim relief granted by this court on 12th February 2024 will continue to operate for the period of 8 weeks from today. So far as the instruction.
Last 2 occasions you have adjourned.
No, Lord. On that day, the only D number.
Can you say this and get the matter adjourned? That doesn't entail to the benefit of the respondent.
So far as the instruction obtained from the counsel from Honorable Apex Court, my lord, they have stated me that.
Members of the Learned Council, what's your name, sir? Mr. Ponda, appearing for the respondent. The matter is again adjourned.
Reluctantly.
And also notice that earlier on 19/6/2025, the learned counsel for the respondent had sought for adjournment. Because again, you will take this plea before the Supreme Court that High Court is not proceeding with the matter.
No, my lord. I have intimated.
Because you are free to say anything now. You have overwritten the Supreme Court order. This you do notice. You did not ask here.
This may be last chance I have to implement this.
It's not a question of last chance. We try to, reason out the thing with you so that you understand what is the consequence.
My lord.
We have no interest in taking up of any matter, but you must understand the consequence of passing order also.
Anyway, next time we have to argue.
My lord.
Huh?
My lord.
Final. Final. The last week of August.
Last week of August. 25th of August.
My lord.
The matter shall taken up 25th of August. No further adjournment.
My lord.
Yes.
I can take
26, your lordships. I just pray it can come up on Monday, 28th.
Monday we are not that sure.
Lordships, any other day. Any other day otherwise. Or a week after.
Any urgency?
No urgency, but because your lordships, I am the appellant and I do have a stay in my favor. So obviously the opposite party would be anxious.
On the appellant, that's my lord, 1 week after.
And the interim to be extended, your lordships.
Interim want to continue till then. Yes.
item 27.
On behalf of Mr. Naik, I will be permitted to place the matter, madam. On behalf of Mr. Naik, I will be permitted to place the matter. To that extent, I will also engage my madam.
Get on record.
I have also filed an engagement. The engagement memo is also filed. The claim of the appellant.
Make use of the mic.
Yes, ma'am.
See how our voice is.
Yes.
Is it not?
Yes.
Yeah.
Oh, madam. The claim of the appellant for promotion and seniority was rejected by the authority on merit. And the other is Honorable Court and the Honorable Supreme Court. This Honorable Court rejected the case or dismissed the case by judgment dated 25/4/2023 at page 14.
Promotion from which cadre to which cadre?
That is the junior assistant to senior assistant, my lord.
Junior
that is what antedating promotion. What it means antedating promotion means he was eligible to be promoted in 2005.
Retrospective
promotion. And what he was given to
junior assistant.
Yes. Junior assistant to senior assistant. Junior senior assistant. What
middle cadre is junior assistant.
Junior clerk plus junior assistant.
What is it? Seniority?
What happened, my lord?
1 second.
Just
1 second.
Yes, my lord.
Is it based on seniority come merit or merit come seniority?
That is seniority come merit is due regards to seniority.
So seniority counts more than the merit. Which is the rule?
That is 1963 rules.
Read.
Suitability or seniority?
That is suitability come merit due regards to seniority. Seniority, my lord.
Then it is merit come seniority only.
I am not on that, my lord.
It is not seniority come merit.
The problem is that the petitioner was awarded with the punishment that he will be debarred for the promotion for one chance. That is in the year 2001. That
now show me the rule which provides for promotion.
That is 1963 rules.
Which is the rule?
The rule is valid Odisha ministerial service method of recruitment and the condition of service of a clerk and assistant in the district offices and offices of the heads of rule 1963.
Yes, ma'am.
Local Act volume?
Local Act, New Act volume. Kindly see my book.
What's the rule says? Just read. Just read. We will go by your version. Just read that rule which provides for promotion.
I am not on the rules. Why I am saying so, my lord? One technical for 2 years. That is there.
Mr. Patra, please. Let us go by step by step. When the court is asking, court is not against you.
No, that I am not.
Basically, that we want to help you.
It is not required because it is misinterpretation of a punishment. That is the crux of the matter.
Maybe.
I will compliment.
That there is no.
Yes, my lord.
By misinterpreting the punishment, is it that the rule will not be followed? The rule has to be followed.
Yes,
please place the rule.
Yes, that is rule your lordship, I will see.
1963 rules.
No, that is the 1963 rules. And general 93 rules that say that is the procedure has been given. But my case is that and there also a clause is there, they have to pass departmental examination. That is also a
You have passed a departmental examination.
Examination he passed between 2001.
Which provision?
My lord,
Which provision?
that is the from appointment and selection and yes, my lord.
Overseas an assistant.
That is rule 9, my lord. Your lordship can see. Promotion.
Rule 9.
Rule 9, my lord. Promotion to the higher post in the cadre of a ministerial service on the district office.
Subject to passing of departmental examination.
Yes, and such a test, if any, as district office in the behalf
and suitability.
That is in the 93 rules. That is also taken up this example. Why I am
seniority is not a factor at all.
In the, as per 93 rules, that is factor.
93 rules, the book refer to that?
That is, it has not been referred on any rules.
No, one second.
Because
whether this rule is amended.
This rule has been amended time and again, and also the latest is 10.2 is there. 10.2 election will be made.
Read amended rule.
That is at clause 10.2.
10.2.
Yes, my lord. First, the selection board shall meet once a year, preferably in the month of June, and prepare a list of a senior class.
Look at the.
Yes, my lord.
When it was amended?
On the amended rule, can you show?
Yes, my lord.
Because the book doesn't show amendment.
No. But many amendments are, but that is not affect my case, or also not I am that.
We want to.
This thing, we want specifically we are telling you that it is merit and suitability.
That is the rule.
Your answer is non-amended rule, it is seniority.
No, that is not here in not. That is in 93 rules. 93 rules, Orissa Civil Service, a criteria for promotion rules 1993. Here that is no, that clause is not.
Right, sir. Then start submitting. Hitting the rule 9.
Here is the promotion, but here it is not, criteria for promotion has not been given. Yes, ma'am.
What's the book? The book, read rule 9.
Yes.
Merit and suitability.
That is in rule 1993, my lord. That is the government has a prescribed.
What's the rule? One door half open.
No.
So that you cannot make noise. One door half open. So they can keep it half open. Half closed.
93.
Yes, it is. 90, sorry, I missed the 93 rule.
So look at this good 63, look at 63.
Yes, ma'am.
So it doesn't show a super subscript or superscript that amended. The eighth portion is amended. Give me your book.
This is my old book. That is the problem. That is the problem.
You should be very thorough because we are spending a lot of time in these things only.
My lord, I am appearing for respondent number 4. And may I be permitted to say, this is an intercourt appeal in which the appellant is required to.
The partner is also medical suitability that was published in 1990.
1990.
My lord,
Your book also, the amendment as 5 is of 82.
That I am sorry, Your Lord.
So that is considering that say may not be correct.
my lord, I may be permitted. My lord, permitted to. My lord, I am appearing for respondent number 4.
Yes.
This being an intra-court appeal, the appellant is required to show the Honorable Court that the order of the Honorable Single Judge is perverse.
Correct.
My lord, the submissions now made on behalf of the appellant are not the issues to be addressed by the Honorable at all. Those are not relevant. There is no dispute with regard to.
Well, Honorable Court put my question.
No, because issues which are not required have been submitted. That is
why promotion is denied to him.
No, not exactly. My lord, I may be permitted. My lord. Promotion has not been denied. I am respondent number 4. While appellant and respondent number 4, I will go to the record subsequently, Miller. When appellant and respondent number 4 were working as junior clerk, there was a departmental proceeding against the appellant, in which the departmental proceeding culminated with a punishment to the effect that she will not be given promotion for one chance. One chance. While if I am wrong, my lord,
No, that is correct.
while the matter stood thus and we both were continuing as such, there was a DPC in the year 2003.
For the first time.
For the first time.
That's the first chance.
No, that is the misconception. My lord, in the 2003, the DPC was held. Neither the appellant nor the respondent 4, myself also, we are not eligible because we had no requisite precondition of passing up people.
In other words, one chance means one chance when both were eligible
and come within the zone of consideration.
You were not within the zone of consideration,
neither the appellant nor the respondent 4 were within the zone of consideration and therefore not eligible. So
next, Mr. Patel, that he was not considered, he had not
passed the examination.
That is correct. Actually, I was not considered.
Pardon, I am
That is my case also. I wanted to point out my lord. Yes.
In 2003, neither the appellant nor the respondent 4 had passed the preliminary accounts examination so as to be eligible to be within the zone of consideration, and therefore their cases were not taken into consideration. The second DPC was held in the year 2005, Miller. And by that time, both of us had passed the examination.
So that will be the first chance.
Will be the first chance. And the appellant was deprived of because of the embargo contained in the order of departmental proceeding, which he did not question.
Thereafter, no DPC met.
Thereafter, he has been promoted or
he has been promoted.
Is not the
in 2005.
Where is the case for you?
Nothing for consideration of whether the first DPC in 2003. When that admittedly, I have
2003, you were not within the zone of consideration at all.
The order was for one chance.
One chance.
That is correct.
It is not a chance at all.
Not at all.
You were not within the zone of consideration.
Then I will have no case, my lord. That is the case. Very beginning, I had the impression that this is the criteria of the crux of the matter. If your lordship will help that is on 2003, since I have not passed.
Also, if the line is also taken into consideration, then being senior, if you say that since I am senior and respondent, I should be. It is very clear, very clear.
It does not mention about seniority at all.
That from very beginning. That's why this point, your lordship kindly again. What
There is nothing, brother.
Just a minute.
A dozen judgments of various high courts.
Only on 26 2003 DPs was held. But
26-3.
28/6 2003.
28.
After DPs was held.
And the second DPC 2005, which date?
Your lordship, the second DPC that is on 4/2/2005.
4/2/2005. Your punishment order is dated?
Letter 12/6/2001.
And
Lordship. No, I have not challenged.
It has occurred.
Admittedly, I have not challenged. My respectful submission would be that during 2004, no DPC was held. Though 10-2 clearly states that rule 10-2, there shall be a DPC each year and within June 2. So they
are held as directly.
That your lordship. So my respectful submission only was that since once I was not allowed to for consideration of promotion, so this should be taken that the punishment passed in 2081 for that chance only. That is only. And if you also hold that no, this will be second. I have no case. I will proceed.
You are more than fair.
Millard.
Why more than? He is more than. He himself is saying. Then what is Millard? You want to pollute the case now?
Oblige, Millard.
This intra-court appeal
2006.
Subsequently, he got it. Which year?
That is 2006. But just after 6 months, in the meantime,
27.
Got your phone?
Yes.
What date were?
That promotion, my lord, that is in 12/2006. But only my predicament was that
no DPC was held in 2000. Therefore, it should be deemed to be a chance which is lost.
Go on.
I would have got the promotion, not the. I would have got it.
And the second thing is, my lord, one DPC was held in 2003 and no promotion was given. In the meantime, we have passed the departmental examination. That is only our understanding.
Point of law calls for our consideration in this case in the following fact matrix. First, petitioner, the appellant suffered punishment order dated 12/6/2001, which in effect had postponed the consideration of his case by one chance. First off, the promotion was accorded to the appellant from the post of junior assistant to that of senior assistant with effect from 2006. First off, he contends that the first chance of DPC was exhausted on 28/6/2003. Is it correct?
Yes.
3, when the DPC had met. And therefore, the effective date of promotion has to be 4/2/2005 when the second DPC met. First one. The answer to the question whether a person is said to have been in the zone of consideration for counting the chance in question without he having passed a departmental examination. First one. Answer to this question has to be a big no. First one. Chance means the situation where the candidate was eligible and qualified for consideration and he would not be considered because of the punishment. First one. Admittedly, the petitioner and appellant and fourth respondent passed the departmental examination post
28/6/2003. Miller. First one. Next paragraph. The second submission of learned counsel for the appellant is that in terms of Rule 9 of 1963 rules, wait, don't pull this one.
Sorry, 10 to 10
Rule 10
to year
10 of 1963 rules, comma, there is a imperative for conducting the DPC every year, and DPC having not been conducted in the year 2005, 2004,
Yeah.
4, comma, after both the candidate passed the departmental examination, comma, at least the effective date of promotion has to be notionally 2004. This again we do not agree, because rule though employs the word shall, is not imperative. First of all, a host of circumstances come in the way of holding the DPC, and therefore such rules cannot be termed to be mandatory. First, even otherwise, the appellant could have tapped writ jurisdiction of the court or such other authority for a direction to hold the DPC in time. First of all, this he did not do. First of all. Next paragraph. The impugned order of the learned single judge is broadly structured on the premises which we have discussed about. And therefore, its unsustainability is not demonstrated. First, in the above circumstances, appeal being devoid of merits is liable to be dismissed, and accordingly it is.
Item 28.
In this IE 1323 of 2025.
Next week. The point is waits for adjournment, correct?
1 week accommodation he wants.
Adjournment.
You agree for a date to suggest it? Yes. Any date convenient you can suggest so that he will agree.
Any date in the one. 38.
Request of the respondent. Yes, yes.
Item 31.
Yes, sir.
May I please?
My blood friend has not filed the entire copy of the writ petition, the annexes. If it is
You don't have full copies.
only it is given the writ petition.
We have the copy.
Yes.
You have copy.
Then no.
You require a copy.
No. I have the copies.
We have copy.
It is on record, not there. That is why I pointed out.
Okay. Which is not?
Sir,
Start.
yes. See, case my lord, he has sought for pay protection.
Pay protection.
Pay protection.
Any of your junior is drawing more than?
No, my lord. That pay protection in the sense, my lord, he's not that case. His junior is. He was in another job.
Where you are drawing X amount of salary.
Yes, my lord. He got another regular post in that university. So he was on that earlier pay protection. He wants that even if I joined in a separate post, so my last pay
cannot be less than that.
Yes, that is his case. Our case is that his earlier appointment is contractual. That must be in the regular establishment.
It is like a file called the upon bond put to file.
Of the university.
Yes.
No.
He was.
Yes, if may permit me, I will just place the 2 to 3 lines. He was initially appointed as a assistant. That nomenclature was something different. Now it has been termed as subject matter specialist. And a decision was taken by the Board of Management of the OUT to grant them pay protection in the event they joined as an assistant professor or the equivalent post. In due course of employment, I was recruited as an assistant professor. On the post of assistant professor, I have to get the pay protection. That is their decision. When they didn't do that, I came before my lord.
Where is that decision?
Yes, that is why I am saying that writ petition is not
incomplete.
That is the resolution.
Writ petition page.
Just move. I have not.
I will clarify all the points.
Very matter lies in a narrow compass.
Yes.
That is
so much discussion.
You refer to the page.
My lord, kindly page 29.
Yes.
Page 29.
29 of the writ petition.
Yes, Annexure 8 of the writ petition. That is the relevant is page 29.
Which paragraph?
My lord, towards bottom, resolution number 3942.
3942.
Towards bottom,
Last part one.
Yes.
Bottom is 3942.
Yes, consideration of pay protection of subject matter specialist, program coordinator of KBK under OUT. KBK is Krishi Vigyana Kendra. So now, subject matter specialist, program coordinator of KBK, appointed and joined assistant professor or associate professor in the constituent colleges and research unit. These are the persons that to get the pay protection. This was approved in this resolution, and the decision thereof is there in page 31, Annexure 9. This was the resolution. The decision is page 31. Decision 26/9/15. In pursuance to resolution number 3942 dated 29/15 of the Board of Management of OUT, the subject matter specialist appointed as program coordinator in KVK and subject matter specialist
allowed protection of pay.
OUT allowed protection of pay in the newly appointed post as per rules. So this was approved. And by this decision was not implemented. That is why it came before the Honorable Court at the first instance. It was decided that yes, disposed of with the direction to consider this. It was rejected. Against the rejection, again you approach. This is the writ petition. 7th seat again I have filed this case and this case was allowed. Now, my lord, there is a development which I have filed another writ petition. I should not. What they have done after I filed a contempt in this for implementation of this order, what they have done, they have withdrawn this resolution of 2015 in a recent decision. That is a subject matter of challenge in another writ petition.
Is it withdrawn with retrospective effect?
No, I think it is not. That is not the spirit of that order. They say we are withdrawing that resolution. That is the writ petition copy is with me.
So according to
that also I have challenge and some intermediate there.
No, if where is the question of challenge? Unless it says it is with retrospective effect.
I am just verifying, my lord. I am not. And I have challenged that. They say, just I am reading out that part. There is another writ petition. Board agreed to revoke its previous order of resolution 3942/2915 taken in this regard in office order by letter dated 26/9/15 issued in the compliance of the board approval. Further, board direct the registered to submit the list of employees who are being affected by the revocation of the order and the financial implication involved.
Your friends are disturbing us. Your friends behind are disturbing us. So when they argue their case, you also disturb us so that they will have equal treatment.
Yes. So this is as I read out to my lord, and this resolution.
No, I am asking you.
Not retrospective.
Whether it is retrospective.
That I just if my lord permit, I will pass on. This is the resolution. This is another cause of action, another writ petition which is pending before the Honorable Single Judge.
Anyways, wait, let us see. He is the appellant now. We have understood the point. Let him say what he wants to.
Yes, my lord. Let's turn to that writ petition filed by my friend. Annexure 1 of the writ petition. Annexure 1 is the writ petition, that is the advertisement relating to the training assistant. That is on the contractual basis. Initially was appointed in response to that advertisement at Annexure 1, page 15. He got appointment on 2006.
Where is your order rejecting relief to him? Where is your order? I'll show it first. We need not go to history at all.
Yes, ma'am. Page 44 of Annexure 15 of the writ petition.
What are the reasons you have given?
Yes, ma'am.
Yes, but people in the last paragraph.
Page 45, my last paragraph.
Last one.
No, don't change. They were reabsorbed as regular employees only.
No, yes, ma'am. They have not been observed. They have not been observed.
But you have said in your order.
In other cases, those he's citing those 13 employees. What has happened? They were initially appointed under OUT, subsequently appointed under KBK. They approached my lords. Your lordship directed to observe them under OUT. So they are not similar to this respondent. They are different footing.
He was on contract employment.
Yes, he was on.
You were discharging the same duties.
No, he was under KBK.
Means
Krishi Vigyan Kendra.
No, where you will take him? Krushi or not Krushi?
He is
not know.
appointed in KBK.
He was appointed in KBK. It was on contract.
On contractual basis.
He was discharging the same duties which regular employees would do.
Yes,
He's a teaching faculty.
Teaching that initially he was an assistant, junior assistant. Research assistant.
Yeah, the question is, but
Yes.
from
That the post
he working as a Krushi in the Krushi Vigyan
Yes,
Vikas Kendra. That was under OUAT or not?
that is under OUAT, and they are not discharging the similar duty. The duty at the earlier post is different from the
First
duty.
party's answer is yes.
Yes.
It is under OUAT.
Yes, Malay, that is under OUAT.
Odisha University of Agriculture and Technology.
And contract employment.
And contract employee.
What was the salary?
Yeah, Lordship, that page 16, the salary was 8,000 to 13,500.
And for regular?
In that KBK, there is no regular post. That is the regular salary.
That is the regular
they-
salary only is given.
Yes,
but
they are-
appointment was tenure was contractual.
Yes, because that as per the because they got the central aid, and they got the central aid, and that service is terminated with the closure of the project.
But that did not happen.
No, that did not. So they continued. All of this, another advertisement was issued. The Lordship turned to that advertisement. Annexed up to page 18.
His continuation. His continuation that junior pathologist is in the scale of assistant professor. Yes.
Junior pathologist.
That's order. You see, it started as KBK, then junior pathologist. That of page 44, and it's a 50. Fifth line.
Annexed up
1.5. I think so. One said the same one. Say page 44, which you are pressing.
No.
Go to the fifth line. While Dr. Raut was continuing in KVK Kendrapada, he was appointed as junior pathologist AICRP on Truth Research Station Kendrapada into bracket assistant professor.
Equivalent. Yes.
And if you mark it, that shows that 15,600 to 39,100.
Regular pay.
Yes.
Scale of cost. Regular pay.
It's the regular scale of pay.
Yes.
At the post of the junior pathologist, that is the scale of junior pathologist.
In which he was continued.
In which he was subsequently appointed.
Correct.
Yes.
So can you deny the earlier pay protection?
Yes. Why you have denied that is the reason why you'll ultimately see the advertisement. Thereafter, why you have denied, what is the ground for denial? Annexed 2 is the advertisement. And annexed 2 is...
What do you say about your resolution?
No, that resolution in respect of the 13 employees, not in respect of all.
Where did not say 13 employees as you are now mentioning.
But in our rejection order, we have mentioned that those 13 employees stand on a different footing.
That's all right. But the resolution does not say that.
Yes, that is
resolution
not,
in so many words say
yes,
pay protection is granted.
I understand. But that resolution is not so specific in respect of 13 employees.
No, it is therefore it applies to everybody.
No, that applies to everybody, but we have not applied to anybody else.
No, that you are not Mughal.
No, not Mughal.
Mughal period is over.
No,
you are only university.
In that, why we have denied. The appointment letter.
Resolution of the university is held a delegated legislation by the Supreme Court at least in 12 judgments.
Well,
is it your case that resolution is incompetent?
No, that is not our case.
Number 1. Number 2, see your conduct. Subsequently, after the institution of the contempt proceedings, you rescind that resolution. Where was the occasion? That means the university knew that rights would emerge from this resolution. Resolution is a delegated legislation because it is passed pursuant to particular power given to a particular body in the university, like academic senate, whatever nomenclatures you have, I don't know.
Board of
generally, under the new economic policy, educational policy, there will be a senate, board of governors, or the academic council, whichever. That resolution gave rise to rights to him.
Yes, ma'am.
How can you take out those rights?
Your Lordship, see the order. It is the order passed by the Honorable Single Judge.
Yes.
That has not been taken into account.
We will take into account.
Yes.
You are in appeal now.
No, Honorable Single Judge had taken into account as he was in a regular service.
No, assuming that he may not be. See, two things you have to show.
Yes.
Order is wrong and is unsustainable.
Yes, I am saying that
in every order there will be one or the other wrong.
No, but that I am saying that order is wrong in the sense. You'll also see the order. What is the order?
Order says regular employee.
Yes.
Instead of contractual.
Why that has been said regular employee, taking into account that
we'll assume.
No, madam. Unless he is a regular employee as per our statute. Statute says only protection will be in respect of a regular employee. That statute says, taking into account that statutory provision, Honorable Single Judge as a regular employee, he is entitled to pay protection.
This is the statute. This is the statute, right?
He is an employee holding like that.
Statute says
scale of pay of
regular, temporary, officiating. All will get the pay protection. This is the statute.
So instead of observing regular employee, you will hold that if he gets a scale of pay of regular employee, that
what difference it makes?
Doesn't make a difference also, suppose.
Yes.
Because I think the single judge looked at that appointment or he is getting that particular skill.
No, my lord, there is a regulation order. There is a regulation order.
Yes,
regulation order is
yes, I am coming to that.
When regulation order is made.
I am coming to that. Annexure 9.
We are asking which date. We will believe you. We have no reason to doubt you.
No, ma'am.
On which date he came to be regularized?
Yes, ma'am.
From my initial date of appointment as a...
Then what remains in your case?
I am coming to that.
They say, but they say that regulation order, there is a sequence of factors. They have regularized me from my initial date of joining 2006. That order is there. Subsequently, they have withdrawn that order of, they say that the regulation order is wrong. So that order I came before this honorable court. This honorable court passed an interim order. They have kept the order in abeyance after the interim order. So my writ petition was disposed. I filed everything in the writ petition. My writ petition disposed of. Now you don't have any cause of action to pursue this case because they have on their own. They have kept it abeyance.
Was kept in abeyance.
Yes. Now in the meantime, my lord, I have been further appointed as an assistant professor on the regular establishment. Well, that order was kept in abeyance. But subsequently, because in the meantime, I became an assistant professor on the regular establishment. So my right to the pay protection matter continues because of these resolutions. What they are now saying, that order kept in abeyance again after my regulation as an assistant professor, they have withdrawn that.
That abeyance order is withdrawn.
Abeyance order is withdrawn, but by the time I became a regular employee, assistant professor, and continuing. So the sequence
is confusing.
No, not confusing.
Yes,
everything is
confusing.
I will give a note with the facts.
No connection with this case.
No.
Why I am showing my very important. That page 30.
Page 32 of WP or RIT-API?
WP, man. This is the regulation order. The following subject matter specialists who have been appointed in KBKs under OUT on contractual basis in the
regularization order. Why are you reading all this?
Yes, I am showing. I want to show my lord, two orders, my lord. That is important, my lord.
The order of regularization.
No.
The first year law student knows what is meant by regularization after daily wages case.
No, I am not on that. Your lordship, are regularized in the respect the dates as mentioned against each as per terms and conditions laid down the letter number 11/10/2010 and of the government of Odisha in Agriculture Department notified by the University dated 16/10/2010. These notifications are withdrawn. These notifications are withdrawn.
Withdrawn after with effect from which date?
From the date of initial issuance.
Sure.
Yes.
So same 28 December 2010 is withdrawn.
Yes, prospective effect.
Page in the writ petition.
No, not in writ petition because he knows that he has said.
No, I have filed it.
Now we are asking.
In count.
One second.
Yes,
election counter is there.
I filed a counter in the writ appeal, that is there.
In writ appeal, he has filed a counter. He has annexed that.
Question of withdrawal. Is it with retrospective effect? Whether your university knows the word retrospective.
Your lordship, page 15.
We are asking you, We can't go on seeing the pages, restrictive appeal, intra-court appeal. Things considered.
They only say superseded, they say that other letter.
In supersession of earlier.
Yes, only that much.
Yes.
No
Because
retrospective.
whatever rights they have already accrued to them, how they can be killed? Rights accrued cannot be killed by these instruments. Because they attained the status in terms of Tulsi Ram Patel. That status you cannot alter. He was a contract employee trying the full scale. Regular scale only. Salary in regular scale.
Regular scale.
Number one. Subsequently, he came to be
Regularization.
Is it not?
Yes, madam.
Thereafter, he made a representation saying that on my appointment to the new post, give me protection in terms of the regulation. You did not consider, therefore he filed the writ petition. Writ court said, consider the application, representation. You consider the representation, and in the last paragraph you said, you stand on a different footing for 13 employees, therefore you are not entitled. How can that be?
This was done in 2014.
Correct. Thereafter,
Yes, ma'am.
learned single judge granted the order. Though he did not mention about the resolution which your friend has drawn our attention to. That resolution, rights should accrue because of doctrine of two things. Doctrine of promissory estoppel and doctrine of legitimate expectations. Two will come to his aid. Then we will supply that as a ground for dismissing your appeal now. Though learned single judge has not considered, you have said that now. Number one. Number two, when he had put the order of the learned single judge in contempt, you have rescinded the resolution itself. And you do not use the word with retrospective effect. This is the case.
No, my lord, no, not after contempt. Not after contempt.
After the order of the learned single judge. Then withdrawal you kept in abeyance because he challenged that withdrawal. You kept in abeyance and therefore his petition came to be disposed of. But thereafter you revoked the abeyance order. See the conduct of the university.
But this was in
doing gimmick.
2014, my lord.
All this happened with respect to him only.
Your lordship, see the withdrawal order and kept in abeyance order of the year 2016.
Yes.
First withdrawal order is the 2014.
Correct. But how that is going to affect his rights?
His rights is not affected anyway.
His rights, right to pay protection arises under the resolution of the university.
Yes, but that, your lordship, that after that resolution, but his regularization was withdrawn by that withdrawal. His pay is not.
That makes your case worse.
Well,
that makes your case worse because if he is not affected by the resolution, then whatever rights that have accrued under the intact.
Yes, but that no right is accrued.
Why?
How, my lord? No right is, why no right is accrued? Initially, we admitted fact, initially his appointment is on contractual basis.
There is nothing.
And that state government resolution says that because of that policy decision,
this appeal dismissed on the following ground. Number one, the employee, though was appointed on contract basis, was drawing the salary in the regular pay scale, is admitted. Number two, subsequently employee got his services regularized and attained the status. First up, there is a resolution which provides for pay protection, and that resolution has been withdrawn subsequent to passing of the learned single judge's order granting pay protection. First off, that is followed by initiation of contempt proceedings. Next paragraph. The orders based on which regularization has been effected have been superseded is no answer to the rights that have accrued already there and that. Next paragraph. Rescinding of the resolution will not affect the rights that have already accrued to an employee since resolutions partake the character of delegated legislation. Learned single judge cannot be said to have erred in treating the respondent employee as being on regular basis for all purposes
purposes, notwithstanding the initial entry on contract basis. First, after all, it is a tenure contract and not a conditions contract. Since admittedly, the salary is drawn in the prescribed pay scale. Next paragraph. The vehement submission of learned panel counsel for the university that the case of the respondent stands apart, stands as a class apart from 13 persons is difficult to agree with, in as much as the very resolution does not differentiate, and that the resolution is not 13 employees specific, going by its text and context. First, dismissed. Yes.
Item 32.
That is family matter. Only family matter. Is that already now? Yes, give.
Date kindly be fixed in item 32.
32.
Kindly speak.
Bunch of cases because people are retiring.
30 years of service completed.
You are the appellate.
Next
What
week
is
that?
Tomorrow the other matters are there.
If you are ready tomorrow, we are taking up. Otherwise, it goes beyond 15. You have to take chance. Sorry. Chance in the sense it may meet, it may reach, it may not reach.
Action for regularization of this. The persons now, they are going to retire.
So for DLR, there is no age of retirement.
We are asking, are you ready tomorrow?
Yes.
He is to get ready, my lord. He is the appellant before.
I am the appellant.
Successful read petitioners.
We'll call this matter tomorrow then.
Yes.
Okay. Call these matters along with 30. Take that.
My lord, I may part. My lord, item 40. Admission to the nursing course outside state candidates. My lord, today. Can it be tomorrow? The
admission date is what?
Admission to the BSc nursing course. They have been directed not the outside state candidates are not allowed to take admission in this. That is the matter, my lord, today.
Okay.
Can it be tomorrow or day after? My lord,
Tomorrow we have difficulty, brother. One day can we have the day after?
One day after. Day after.
Wanted to see.
Again, my 36.
Another item.
Last item I thought you not specifically feel.
But you have seen so much time is
Yes, sir. Short date.
which year matter it is? 24. In the third week of August, whichever date.
Item number 36.
August.
Yeah.
Item number 36.
Rest of the matters you can mention to our court officer, we will distribute.
My item is item number 36, madam.
Wherever interim order is there you have to continue the interim order.
It is urgent matter, my lord. Item 36.
Yeah.
Item 30.
Please to direct to deposit two set of books, my lord. That book is not available.
Which book it is?
Service under the state.
Service
same, my lord.
It is available, na?
Not available, my lord.
Which Panda is not available?
Out of print.
Out of print.
In Amazon, did you check?
No, Amazon available.
Okay. Then law relating to service by Samaraditya Pal. Okay, give that book.
That is available.
Yes, that book you can give. Two books.
LexisNexis. That is LexisNexis.
That's available.
Before how many books were?
Two sets. Two books or another Pula system will provide.
No, 2 books. 2 volumes.
No, it's only 1 volume actually. One volume book it is.
1 volume, 2 copies.
Two copies.
Same, instead of that you can give 34. Since Justice Rama Joyce's book is not available, come on. The the service, the law relating to service by Samraditya Pal.
Law relating to public service.
Public service, you are right. Law relating to public service by Samraditya Pal be presented.
2 copies.
Two books. 2 copies. Okay, right. Okay, just structure that. All right.